to the photographs. The people have supplied me with testimony of Dr. Tyler in that regard, where you asked her about things that she considered. And she indicated that she looked at all sorts of photographs in albums. And then you expanded on that, looking for photographs that would show interaction between either parent and the defendant, Eric Menendez.
I haven't seen those excerpts, Your Honor.
All right, you can look at them right now, and then we'll complete this issue. I've given you my copies of those. And what else is it that council wished to discuss?
Your Honor, I provided the public notes, transcript reference.
Right. Yes, and that conforms with what I indicated we should do. We only received the first page of that document. The top portion that describes the defendant and his position, and then the bottom portion of that first page describing Mr. Stevens and his responsibilities. So if you want to redact it in that fashion, it would be received. Xerox it, whatever you want to do it. And that would be pretty much what I said yesterday. All right, any other matters that council wish to discuss?
Raise a discovery violation with the court. And as the court will recall, just prior to the testimony of Judeline Smith, we informed the court that she had indicated to us that she had been in contact with the prosecutorial authorities working for the state of California, and that we suspected that there was a criminal case concerning Dr. Oziel that had been referred to the Los Angeles District Attorney's Office. And the court ordered that any documents pertaining to that any charge be handed over to the defense. During the cross-examination of Ms. Smith, Mr. Curry did provide me with a very lengthy package of documents. And last night was the first chance that I had to go through these documents in detail. And it appears, Your Honor, that the State of California Department of Consumer Affairs Medical Board of California began an investigation of Dr. Oziel sometime in October of 1992. And in March of and the investigation was based on the writing by Dr. Oziel of a letter, which has been marked in this case as exhibit number 327. It's a letter purportedly signed by a Dr. Munjak, and Ms. Smith testified to the circumstances surrounding her obtaining of that letter. That letter and the writing of it by Dr. Oziel was the subject of a criminal investigation by the Department of Consumer Affairs. And based on an expert handwriting, in fact, the letter was written by Dr. Oziel and not by Mr. Munjak. The medical board referred the case to the Los Angeles District Attorney's Office in a report, which states in part, allegations substantiated present case to the District Attorney's Office and transmit to the Office of the Attorney General for prosecutorial action. And that report that I just read from is dated March 8th, 1993. Also provided in the documents by Mr. Kuriyama is a charge evaluation worksheet from the Los Angeles County District Attorney's Office. And that charge evaluation worksheet is dated April 19th, 1993. And it's signed by a deputy district attorney by the name of Tyson, Alan Tyson, Tyson. And the report indicates that Dr. Oziel is under suspicion for a violation of Penal Code Section 134, which is false documents to a court for court purposes. And there are several coded reasons on this charge evaluation worksheet. One of them is lack of sufficient evidence. That is not marked, but what is marked is as the reason for non-prosecution, other. And then in a comment on the charge evaluation sheet, it says, suspect prepares a letter for a patient, psychological counseling, stating that during physical illness, the patient is incapable of driving. This is, according to the patient, to be used for the ostensible purpose of obtaining a continuance in a small claims action. Suspect signs the letter with the name of an MD who is director of the office he works in. A few days later, the patient notices that the letter is not signed by suspect in his name. The patient confronts suspect and obtains a second letter signed by suspect in his name. Original letter dated 8/30/89, second letter dated 9/3/89. Patient does not bring to attention of law enforcement unit until 10/29/92, whereby when being interviewed regarding other allegations of misconduct made by patient. Since patient discovered the fact that suspect had prepared a false document no later than 9/3/89, this would be the date of discovery pursuant to Penal Code Section 803C2. This being the case, prosecution for the offense would be barred by Section 801 PC. And it's our position, Your Honor, that this whole matter, that is the pendency of these charges and the prosecutor's rejection of the charge, which had been substantiated by the medical board, certainly should have been brought to our attention prior to the cross-examination of Dr. Oziel, which took place in August. And as the court will recall, Dr. Oziel specifically testified that Ms. Smith was not his patient. He specifically disclaimed that he had ever diagnosed or written any sort of a document which purported to be a diagnosis for Ms. Smith. And yet at the time he gave that testimony, the prosecution was in possession of documents indicating not only that he had made a diagnosis, but that he had fraudulently done so. And as a result of that fraudulent diagnosis, they had a criminal prosecution which had been pending and they had rejected. And I think it certainly goes to his credibility, and at the very least goes to the issue of bias, interest, or motive. The fact of pending charges, I think, is Brady material, which is discoverable without a request, and there has been no explanation given to us as to why this material was not turned over. In light of the discovery violation, we would move to strike Dr. Oziel's testimony, or in the alternative, we would ask the prosecution to stipulate that, first of all, a handwriting expert examined the document in question, that is 327, and it is his opinion that that document was written by Dr. Oziel, not by Dr. Munjak. And I have spoken to Ms. Bazanich about that issue. She says she is willing to stipulate to that fact, but she is not willing to stipulate to the fact that based on that document, a case was referred to her office by the medical board, and that the Los Angeles District Attorney's Office declined prosecution.
Your Honor, that's not precisely what I said.
All right.
First of all, this was not put to me in terms of a discovery violation. If I'd known that Mr. Burt was going to make these allegations, I don't think I would have agreed to stipulate. However, I told Mr. Burt that I would stipulate to the fact that the letter has been examined by a handwriting expert and it is Dr. Oziel's writing. I also indicated that I don't feel that the rejection is relevant, but that if the court rules it to be relevant, then I would stipulate that the case was rejected. So the issue was not whether I'd stipulate to it, but rather whether the court found it to be relevant.
That's true.
The other thing is, Your Honor, this was not a pending criminal prosecution. This was an investigation, apparently, that was rejected. I had no knowledge of this until Mr. Burt asked me to get the report. At that point, I asked Detective Zoeller to get the report. He got the report from the Beverly Hills office, and it was given to Mr. Burt. So I don't know what he's talking about, that there's a pending criminal prosecution. There was no pending criminal prosecution at that point.
Well, there was an investigation that was presented for consideration of filing a prosecution, filing a charge.
Yes,
that I had no knowledge of until he told me about it. I don't
Well-
follow Julie Smith to see what she's doing
The
every
issue
day.
is not Mr. Kuriyama's personal knowledge. When a district attorney's office has knowledge of a pending criminal prosecution, the whole office, if anyone in the office has knowledge of that, it's the obligation of the office to reveal that information to the defense. And unless they're claiming that no one in their office had knowledge that this matter was referred, then I don't think they're on good grounds in claiming ignorance of this fact and that they somehow were excused from providing this discovery.
Right, the people have indicated they are willing to stipulate to the handwriting being that of Oziel, and also that a charge was presented and rejected by the district attorney's office in April of 1993. Is that right?
Yes, and the reason of the rejection is the statute of limitations. But my point was, I didn't think it was relevant that the case was rejected. I believe that she testified to that, but
Testified to what?
Testified to it. Corroborates her.
She testified to what?
testified the case was rejected as far as I can remember.
All right, well, her credibility was something subject to attack. I understand that. All right, in this regard, the people constructively were in possession of this information, even though the prosecutors in this case were not, the district attorney's office was. The court doesn't find any intentional violation of discovery in this matter. It was just, from what's been presented to me, an inadvertent situation where matter was presented to other prosecutors without knowledge of these prosecutors. The proposed stipulations would seem to deal with the matter appropriately, and therefore the court would rule that it's relevant and that the willingness of the parties to stipulate to those issues that have just been alluded to is a sufficient means of dealing with the subject. All right. You can frame your stipulation between yourselves as to how you want to present it to the juries. As far as the photographs and the transcripts relating to them, did you wish to be heard?
Yes, Your Honor. Looking over these transcripts, what appears to have been testified to is that both of my experts had.
Actually, this is all Dr. Tyler. That Dr. Tyler had access to the photographs, and the only thing she's testifying to specifically are the photographs of where Eric was quite young and with his mother, and photographs of Jose and Lyle when Lyle was real small. And this has to do with the photographs of them when they were basically babies. And I have offered all along to make those photographs, that book, which contains the early pictures, which this witness is testifying about, available to the prosecutor.
No, she was asked more than just
She said
about
she
one
looked at-
album. She was asked by you about
Yeah, I'm
all
looking at it.
sorts of albums that she
She was
looked
asked
at.
if she saw them. Now, she wasn't asked anything specific about anything but, did you look at all of those photographs that you could find where Eric was quite young and with his mother? Yes. And did you see any photographs in which she appeared to be interacting with the child? No. Do you remember seeing any photographs of Jose Menendez with Lyle when Lyle was real small? Yes. These are the only ones where she's offering an opinion. And the same is true in the photographs of that she's referring to when she sees a child being handled like a piece of baggage by the mother. And that's the same bunch of photographs of when the children are babies and the parents are holding them. And those are all in the same book that I've offered to let Mr. Kuriyama see all along.
Based upon the nature of your questioning of the witness, the court is ordering you to produce all the photographs shown to Dr. Tyler. It seems that these were all considered by her and referred to her in her testimony, and it's quite clear that that was the nature of your questions of her. And you said you would have them here this morning, so.
No, I said I can get them here
Yeah,
this morning.
that's what I meant. You can call your office and have them transported here for the prosecution to review. All right, any other matters before we proceed with the juries? All right. Both sides ready to have the juries come in? All right.
And can we have a break sometime this morning so that the phone call can be made to get the exhibit?
I'll let them make the phone call right now.
We can
Sure.
She wasn't shown until 11.
All right, let's take a 5-minute, let's have the juries in and we'll start up at exactly 11 o'clock, 10 o'clock rather, I'm sorry, 10 o'clock. With their attorneys, the people are represented and we have both jury panels in court. Good morning, ladies and gentlemen. Good morning. And as to the gold jury, we've substituted an alternate juror for one of the jurors on that jury panel who was unable to continue on as a juror and due to a physical situation. She's giving birth to a child and couldn't obviously be here. So we have substituted for that juror and also another alternate.
One of my favorite supplements is Cunol turmeric. Turmeric helps with healthy joints and inflammation support, and Cunol has the #1 doctor recommended form of turmeric. Cunol, the brand I trust.
A juror on that gold jury has been ill for a couple days and she has been excused. And we're now ready to proceed with the trial with both juries present. People have further evidence to offer?
Briefly.
Okay. No. And would you say your name again for the record?
Leslie H. Zoeller.
I'll remind you, you're still under oath.
Yes, Your Honor.
Your Honor, I have here a photograph that may be marked as exhibit 397, please.
Yes.
May I approach, please?
Yes.
Detective Zoeller, I'm showing you exhibit 397. Could you describe briefly what this is?
It's a photograph of 722 North Elm, Eric Menendez's bedroom. And it shows from inside the room, showing a desk, a dresser with drawers open and an open door.
And is that approximately the condition of the room when you were at the home between the 20th and 21st of August of 1989?
Yes.
Thank you. Detective Zoeller, on the 24th of May of 1993, did a man named Ed Fenno come into the Beverly Hills Police Department for an interview?
Yes, you did.
During the course of that interview, was Mr. Fenno asked particular questions and did he give answers?
Yes.
And at one point, did he discuss an incident involving Eric Menendez and Berkeley, UC Berkeley?
Yes.
And could you tell us what Mr. Fenno told you during that interview in my presence and Mr. Kuriyama's presence?
He was asked if, to his knowledge, whether Eric was looking forward to going to UCLA. And his reply was yes. He was really looking forward to going to UCLA because they had a great tennis team. And then he added that Mr. Menendez, Jose Menendez, the father, was upset with Eric because Eric turned down or decided not to go to Berkeley.
After he made the statement about the fact that Eric Menendez had turned down Berkeley, was he asked about that again by either myself or Mr. Kuriyama?
Yes.
And did he reply in the same manner?
Yes, he restated the same statement.
And lastly, have you viewed the videotapes made by Ms. Erdely, the defense investigator, dealing with the portions which deal with Century City?
Yes.
And have you since then gone by Century City to see if you can locate the area which she described in her testimony as a taxi zone?
Yes.
And is there in fact a taxi zone in the area that she identified as such?
I'm objecting for the question.
Overruled.
Yes, I did.
And what did you find?
It was the area where she went that she described, I think, as a taxi zone. It was red curbed and with placards stating valet.
Is there valet parking available at Century Plaza?
Yes.
And are the curbs surrounding the shopping?
Where are you talking about? You said Century Plaza?
I'm sorry, Century City Shopping Center.
That's correct.
And did you see anything else around there that resembled a taxi zone?
No.
I have nothing further at this witness at this time.
Cross-examination?
Just briefly, can I remain seated, Your Honor?
Yes.
The valet parking area at the Century City Shopping Mall, isn't there a staircase that leads directly up from the valet parking area and in a straight line to the ticket booths of the AMC theaters.
Yes.
And there is a long stretch, a fairly long stretch of red curb, is there not, before the place where the valets themselves actually stand.
That's correct.
And the area where the staircase is not the area where the valets stand, isn't that true?
It's actually in between the long section of red curb and where the valet stands.
Exactly. Now, the photograph you just identified as being of Eric Menendez's bedroom. What number did you get? 397. I'm just going to hold it up to you from here. Is it still your testimony, Detective Zoeller, that there are no windows in that bedroom that overlook the pool area and look onto the guest house?
No, it is not.
Okay, so there are at least 2 windows in that bedroom that look out over the pool area, the tennis court area, and towards the guest house. Are they
That's
not?
correct.
Thank you. Let me just see if there's anything else. I have nothing further.
Nor do I.
On this aspect, we're going to.
Yes. Anything else on behalf of Lyle Menendez? All right, thank you. You may step down.
Thank you.
No, I just-
All right.
Your Honor, I'm just going to read the stipulations and then ask it at the end because I believe we discussed this already with counsel. Counsel, will you stipulate that Exhibit 394 is a true and correct copy of the movie listings for the AMC Century 14 theaters as published in the Los Angeles Times for Sunday, August the 20th, 1989? Will you further stipulate that the movie Batman has a running time of 126 minutes and that the movie License to Kill has a running time of 133 minutes? Will you also stipulate that the Big Five sporting goods chain shipped all of its handguns out of the Santa Monica store referred to in the testimony by March of 1986, and that the chain stopped selling handguns in all of its Southern California stores by November of 1986? Will you further stipulate that the play Hurly Burly was shown at the Westwood Playhouse between November the 9th of 1988 and January the 15th of 1989? And lastly, will you stipulate that the television movie, The Billionaire Boys Club, aired on national television on July 30th and 31st, 1989, and was shown in Los Angeles, California, and Tampa, Florida? It was aired from 9 p.m. to 11 p.m. on those 2 nights. Do counsel so stipulate? Thank you. Your Honor, at this time then, subject to the evidence that people would rest their rebuttal case.
All right, people rest. Any rebuttal?
Yes, Your Honor.
All right, you may proceed.
Do you recall Ann Ingram?
Someone get her?
What's the next number? 398 is next.
If you would stand right where you are and face the court clerk, please. Raise your right hand.
You do solemnly swear that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God. Please take the stand and state your name for the record.
My name is Ann Ingram,
Could you spell both names, please?
ANNINGRAHAM.
Your Honor, at this time, I have a piece of paper, actually, it's another paper stapled over it, but I'd like to mark this as next in order 398.
All right.
I would ask counsel for the people if they would stipulate that this piece of paper contains on it the 3 names that the witness Grant Walker wrote, indicating the people whose pool he serviced on Saturday, August 1989. You said that?
Yes.
Mrs. Ingram, do you know Grant Walker?
Yes, I do.
And does he service your swimming pool?
Yes, he does.
And does he currently come on Saturdays?
Yes, he does.
When did he start working for you?
In late March or early April of 91.
1991. That's
That's correct.
And Mrs. Ingram, do you live on Lucerne?
Yes, I do.
Do you live in the 400 North block of Lucerne?
And no, I don't.
I have nothing further, Your Honor.
Examination on behalf of the co-defendant. Cross.
Yes, briefly, may I stay seated?
Yes.
Mrs. Ingram, what is the name of the person who referred Mr. Walker to you?
Marianne McCole.
And where does she live, please?
Could the witness write the address rather than?
No, just tell me the street. Do you know the street that she lives on?
Now, presently,
No, at the time that you got the
at the
referral.
time that she made the referral, she lived on 2nd and Van Ness.
And is that in the Hancock Park area?
I don't know the precise boundaries of what is considered Hancock Park area, but it's in the neighborhood.
It's east of Hancock Park, is that
Yes,
correct?
it's east of Hancock Park.
Thank you very much.
You're welcome.
Anything else?
No, Your Honor.
All right, thank you. You may step down. You're excused.
Thank you.
And your next witness.
Our next witness, Your Honor, is Virginia Valdry.
You would stand behind the court reporter and face the court clerk and raise your right hand, please.
You do solemnly swear that the testimony you may give in the cause not pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God. Just take the stand and state your name for the record.
My name is Virginia Valdry. I reside at
Spell your last name, please.
V as in Victor, Aldry, Valdry.
Mrs. Valdry, did you live in the 500 South block of Lucerne in 1989?
Yes, I did.
Have you ever lived in the 400 North block of Lucerne?
No, I haven't.
Mrs. Valdry, in 1989 and up to the present, did a man named Grant Walker work for you in servicing your pool?
87 to the present.
And does he currently service your pool on Saturdays?
Yes, he does.
And when did he start servicing your pool on Saturdays?
As far as I could remember, he's been serving it on Saturdays. When he started midweek to get the pool chemical and everything balanced, but I don't remember how long he did that.
Do you recall telling Miss Erdely, our investigator, on last Tuesday, that the fall of 1990 would be the earliest that he started on Saturdays?
I told her approximately, but I didn't really remember, being that it's been that long. I don't log that.
Did you also tell Miss Erdely that it's been 2.5 or 3 years that he's been coming on Saturdays?
I told her up until, like I said, I really didn't keep a record, so I don't know when he actually started, but the period that he did service my pool on midweek was just a short period of time.
So now you're saying that you didn't tell Miss Erdely that he was servicing your pool midweek up until 2.5 or 3
I
years?
told her I didn't really remember it.
Okay, so you're saying you didn't tell her 2.5 or 3 years?
I don't remember what I told her.
And you didn't tell her the fall of 1990, is that what you're saying?
No, I didn't know.
All right, I have nothing further.
Any examination by the co-defendant?
I'll just bring it up.
Cross-examination?
Yes. Mrs. Valdry, do you remember approximately when in 1987 Mr. Walker began to clean your pool?
It was in the summer, probably was June.
And does he still clean your pool?
Yes, he does.
Presently, when he cleans your pool, does he come on Saturdays?
On Saturdays.
I believe you indicated that when he first started cleaning your pool, he had to do something to it to get the chemicals correct.
I had my pool resurfaced, and the people that resurfaced it and tiled it gave me Mr. Walker's name because he was good at getting the chemicals started.
Non-responsive.
Right, the objections overruled, the answer is still.
Okay. My next question then is, so for a period of time, he had to do something because your pool had been redone, is that correct?
Yes.
And do you remember approximately how long it was that Mr. Walker had to make these adjustments to your pool before he started just to service it regularly?
I think it was about 3 weeks.
And after that time, did he begin to come on Saturdays?
Yes, he did.
Okay. Now, do you keep any kind of records to show when Mr. Walker shows up at your house?
No, I don't.
Okay. Is it your best recollection that Mr. Walker, aside from this initial period of time, has always come to your house on Saturdays?
As far as I remember.
And have you referred Mr. Walker to any of your neighbors?
No, I haven't.
Do you know if Mr. Walker services any of your neighbors any of your neighbors in 1989?
No, I don't.
Okay, thank you. I have nothing further.
Anything else? All right, thank you. May step down. You're excused. Your next witness.
Call Mark Slotkin, Your Honor.
Step forward and stand behind this the court reporter right here and face the court clerk, please.
You do solemnly swear that the testimony you may give in the cause after before this court shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Skating for over 45 years has taken a toll on my body. I take Cunol turmeric because it helps with healthy joints and inflammation support. Why Cunol? It has superior absorption compared to regular turmeric. Cunol, the brand I trust.
It's Mark, M-A-R-K, Slotkin, L-O-T-K-I-N.
Mr. Slotkin, behind you is a diagram, which is exhibit number 6 of 722 North Elm Drive. Do you see that diagram?
Yes.
Are you familiar with the location of 722 North Elm
Yes.
Drive? Could you tell me how you're familiar with that location?
I built the house.
And when did you build the house?
It was completed about 1984.
And did you live in the house yourself?
Yes.
During what period of time?
From 1984 until its sale.
And when was it sold?
1988. I had rented it a few times, but basically I live there.
And who did you sell a home to in 88?
To the Menendez family.
And who did you deal with, if anyone, in the Menendez family regarding the sale?
Well, mostly the broker was in between, but I did have a chance to meet the Menendezes, and I dealt a little with them.
All right. And did you have much contact at all with Mr. and Mrs. Menendez?
More with Mrs. than with Mr.
And when you were living at the house, did you have some changes done within the home itself? Structural changes?
Overall, you can answer the question.
Well, I built the house, so I built it from scratch, so it wouldn't be a change to me.
Do you recognize the floor plan that's depicted in that diagram, exhibit number 6?
Yes.
Is that accurate insofar as the location of the stairs and other rooms is?
No.
What is inaccurate about the diagram?
The stairway, should I point?
Yes, if you want to step down there, feel free to do that.
The stairway, this one here, was never built. That's incorrect.
All right.
That stairway was actually the original stairs in the house, and we elected to take them out, and we expanded the library, became bigger, and it abutted the dining room. And the other problem is that in the maids area and the service area, there are no closets shown there.
When you say the problem, you mean the problem with the diagram?
Yes, they exist, and the diagram doesn't show them.
All right. Now, the location of the maid's bedroom is in correct location there?
Yes.
And could I approach you with this?
Yes.
You see on the right-hand side of the diagram, there appears to be some sort of a window or a door drawn in there.
Yes.
And is that true? There's a window there that faces out?
Yes.
And on the bottom of the diagram, it says maid's bathroom, and there's a door which leads out. Is that accurate?
Yeah.
Accurately depicted on the diagram?
Yes.
Could you tell us what the construction of that house was like in terms of soundproofing?
Well, the whole house had interior insulation and exterior insulation in it, soundproofing, and it had, in most of the rooms, 2x6 studs. The walls were a little thicker.
How about in the maid's room?
My recollection that there were 2x6 studs for structural value, but I couldn't swear to whether they're 2x4 or 2x6.
I have a series of photographs I'd like you to mark this. Next to
399 is the next exhibit number.
6 photographs. Could those be marked collectively?
Are you going to refer to them individually or? All right, just mark there. How many?
6.
Use letter designations 399A, et cetera.
Mr. Slotkin, could I approach a witness?
Yes.
Your Honor? Thank you. You said the diagram was inaccurate and not depicting a closet area in the maid's room. Could you, with this marker, draw in where the closet would be on the diagram itself? And in the family room, in the wall that adjoins the maid's room, is there something against that wall?
Yes.
And is that a bookshelf that lines that entire wall?
Yes, I didn't build the bookcase in, but the bookcase was built after they purchased it.
And did you go into the house after the Menendez parents purchased the home?
Yes.
Did you go into the family room at some point?
Yes.
And did you see the built-in bookcase along that wall where you've written in bookcase on the diagram?
Yes.
Showing you exhibit 399A, can you tell me if you know what's depicted in that photograph?
Excuse me, may I precise the
Yes.
This is the maid's room.
All right, and in that photograph, is the maid's bed depicted on the right?
Yes.
And on the left, there are two adjoining, what appears to be two adjoining doors. Are those doors which lead into the closet in the maid's room, which you've drawn on the diagram, exhibit 6?
Yes.
And that's an actual closet. It's not a fake door that leads nowhere. Correct?
No, it's a bifold closet that holds clothes.
And how
It's a by what?
Bifold closet.
and how wide is the closet? Approximately.
Well, my recollection was that it went the length of the room, but from that photograph, it looks like it was a little narrower. But I believe that the head that you could open the closet and reach around, and so there would still be there'd still be in the maid's area an area for them to sit, but the closet went around a little bit. That was my recollection, but it looks like it's about 8 feet wide.
And showing you 399B, can you tell me what's depicted in that photograph?
That is the game room with the rough cedar paneling in it, and the bar, and the bookcase that the Menendez is built in.
The bookcase is drawn in on exhibit 6. Correct?
Yes.
And 399C, if you could tell me what's depicted in that photograph.
That is the maid's room with the window that led out to the outside.
All right, and looking at the diagram, is that the window that is depicted on the right side of the maid's room?
Right there, yes.
All right, you're pointing to the right side of the diagram where a window is.
Right.
provided.
Right.
And 399B, can you tell me what that depicts?
That is the maid's, part of the maid's bathroom area that led to an exterior door to the backyard.
And on the diagram, that's depicted in here at the bottom,
That's correct.
showing a door leading out toward the bottom of the diagram.
Right.
And 399E, can you tell me what's depicted in that diagram with reference to where the maid's window would be?
The maid's window would be toward the left center of the tennis court fence.
Could you take a marker and just put on the photograph where the maid's window would be depicted in there?
Well, the maid's window wouldn't show because it's lower than the fence, but it would be where the arrow would point to.
You're drawing an arrow on the photograph indicating that the window is next to a fence which separates the house from the tennis court.
That's right.
And Exhibit 399F, is that another photograph showing?
Yes, that's the window. That's depicts the maid's window as well as the laundry room door.
Could you again draw on the diagram where the maid's window would be? And you've done that. And the shrubbery on the left in that photograph would be the shrubbed wall that separates her window from the tennis court, correct?
Yes.
Now, are you familiar with where Eric Menendez slept in the house after the Menendez family moved in?
Yes.
And where is Eric Menendez's room in reference to the maid's room?
The window actually isn't showing here, but it would be on the second story and would be above the living room. But it would be on a second story up.
Right. And based on your knowledge of that house and having lived there, do you have an opinion as to whether or not if someone was pounding on the door of Eric's bedroom, you could hear that noise down in the maid's bedroom? Did you spend some time in the maid's room when you lived there? Were there times when you went into that room?
Yes.
Could you, standing in that room, hear noises that were taking place in other parts of the house?
Objection assumes facts not in evidence.
You're asking just when he was there, did you hear sounds in other parts?
Yeah.
I think that you could hear something in the laundry room and certainly something in the breakfast room. If you can hear and hear.
That's not the question. It's all of you, when you were in the maid's room, were you able to hear sounds coming from other parts of the house? Did you actually hear sounds?
Yes.
And could you hear, for instance, if someone made a loud sound in the area where Eric Menendez, where his bedroom is, could you hear it in the maid's room?
A loud sound?
Yes, such as pounding on a door or something like that.
I don't think you could hear that.
Your Honor, I move to strike as improper opinion.
Objection sustained. The answer is correct.
Did you ever, when you were in the maid's room, were you ever, during the time that you lived in the house, able to hear loud sounds emanating from the room which became Eric Menendez's room?
Objection assumes facts not in evidence. Such sounds existed.
Sustained as the formal question.
Did you ever, during the period of time that you lived in the house, when you were in the maid's room, hear loud noises emanating from anywhere in the house?
Objection assumes facts not in evidence.
We never heard, no.
And in your opinion, was the maid's room soundproof enough so that it was not a situation where the walls were thin and you could hear throughout the house?
Objection, a lack of foundation and proper opinion.
Yeah, it's compound. Sustained.
Could you hear, when you were in the maid's bedroom, a conversation taking place in the family room?
No.
And could you, when you were in the maid's room, hear conversation taking place in the, do you know what the foyer area of the house means? Where that is? You're pointing to in the diagram. Could you,
Is that the foyer?
yes,
You couldn't hear anything.
could you hear conversation, people talking in the foyer area? If you were in the maid's room, could you hear it?
Objection, lack of foundation.
Establish whether he's talking about what he actually did or did not hear, or just wasn't.
Well, when you were in the house, were there times when you would be in the maid's room and there were other people in the house in other rooms?
I can't say. I'm sure that I was in the maid's room occasionally or in the laundry room, and there were other people in the house.
And did you, during those periods of time, could you hear a conversation taking place in other rooms in the house?
Objection assumes facts not in evidence.
Sustained. You can answer the question. What was your answer?
What was the question again?
Okay.
Your Honor, I thought it was
Thought it was
sustained.
sustained.
You said sustain.
No, I said, go ahead, ask the question. You can answer it.
Tell me the question again, please.
Were there ever periods of time when you were in the maid's room while other people were in the house where your attention was attracted to conversation that was taking place?
No, that was not the case. You couldn't hear into the other rooms from the maid's room.
Now, after, are you familiar with the date that the Menendez parents were killed?
August of 1989.
And after the killings, did you go to the Menendez home shortly thereafter?
Yes.
Do you know when that was in relation to when the killings had taken place?
My recollection, it was the day or so afterwards.
And did you, on that occasion, when you went to the home, meet Eric or Lyle Menendez?
Yes.
And was that the first time you had met them?
Yes.
And what was the purpose of meeting them at that time?
The house was on the way to work for me, and I wanted to stop by and express my condolences.
And did you in fact do that?
Yes.
What did you say to either or both of them at that time during that conversation?
Objection, hearsay.
Is it offered for the truth of the matter
No, it's
asserted?
for the non-hearsay purpose of showing what was said after he made the statement.
Objection overruled.
I introduced myself. They were I drove into the driveway, and they were in the courtyard, the driveway courtyard, with some security people. And I walked up and introduced myself and told them how sorry I was, and if there was anything that I could do for them, in the future, to please call on me, that I could be a friend, and I was a friend of their family, and I'd like to continue on if it's something I could do for them.
And when you expressed your condolences, how did Eric and Lyle Menendez appear? First of all, Lyle Menendez, how did he appear? Was he happy, sad? How would you characterize his demeanor when you had this conversation?
He was very sad.
And how about Eric Menendez?
Grief-stricken.
Now, when you expressed to them that you were available, should they feel the need, did they in fact contact you at some later time?
Yes.
And did you indicate, other than saying if you needed a friend, anything else that you were available to do?
Well, I said if they needed some, fatherly advice or, business advice, I felt that I was an astute businessman in Los Angeles and could, make sure that they, went on the right path if they needed some help.
And at some point after you had that conversation, did either or both of them contact you and make an appointment to come and see you?
Yes.
When was that?
About 2 weeks afterwards, they called.
2 weeks after the first conversation?
Yes.
And did they call to make an appointment with you?
Yes.
And did they in fact keep that appointment?
Yes.
And did you give them certain advice at that time?
We spoke for a couple of hours, and I offered them some suggestions.
Were they seeking your counsel or advice on anything?
I think so.
What were they asking?
They were asking what direction I thought their lives should go in, after this tragedy.
And am I correct in saying that this is the second conversation that you had with them?
Yes.
And they were
The third conversation.
When was the
phone call to make the appointment, the initial meeting, and then the conversation.
And they were asking you for what direction their life should take at that point?
Yes.
And what advice, if any, did you give them?
Objection, irrelevant and hearsay.
Overruled.
I had understood, when with my dealings with Kitty Menendez that
Okay, that's non-responsive.
What advice, if any, did you give them?
I advised them to become professional tennis players.
And did you indicate why they should do that as opposed to some other occupation?
Well, this advice was based on the fact that they told me that they were of world-class, they had world-class ability, and I told them that they should exploit that ability.
And was there some concern expressed by either or both brothers as to whether they should stay in school or go to school?
Yes.
And what was said in that regard?
Lyle was pretty much out of school from Princeton, and Eric was talking about enrolling at UCLA. And I had advised them that that Eric could take 2 courses. She should enter UCLA and enter their tennis program, and he could play in the NC2A tennis tournaments, and that both of them should get a professional coach to help develop their abilities and give them a discipline regimen.
And did you advise them in terms of whether it was a good idea to go to school as opposed to follow this career as tennis players?
Well, in Lyle's situation, he was not going to go back to school, and he definitely wanted to go into the tennis thing. And Eric was vacillating between going and playing tennis and going to school, or just solely doing tennis. So I told him he could do both if he was able to get into UCLA, but that they should keep the coach, or they should hire a coach.
And did either or both brothers also seek your advice on other investments, business investments? At that time?
Yes.
First of all, Lyle Menendez, what information or advice did he seek from you?
Lyle needed a car. His car was falling apart. He said he needed a car, so we discussed.
I would object to this.
All right, do you object to this answer that's been given, or are you objecting to
No, I
any further?
object to any further questioning along.
Okay.
Let me ask you if I could ask another question.
All right.
And how about Eric Menendez? Did you discuss with him?
Yes.
And what discussion did you have with Eric Menendez?
Eric needed transportation also. So we discussed what kind of car he ought to buy, and he decided on a Jeep, an open air Jeep. And we discussed where they ought to live and that sort of thing.
Right. And after that meeting with them, did they continue to seek your advice and counsel?
Well, we became more friendly, and it really wasn't so much for advice as counsel as it was that we were friends, and occasionally these things would come up and they'd ask me what I thought, and I told them so.
Thank you. I believe that's all I have.
Any examination on behalf of Eric Menendez?
Yeah, just very briefly. Mr. Slotkin, apart from having been the person who built this house, you do have a very large and active business in Los Angeles, do you not?
Yes.
Are you comfortable telling us what it is?
Yes.
Okay, tell us what you do.
Objection, relevance.
Overruled.
I'm in the antique business.
Are you in fact the owner of a company called Antiquarian Traders?
Yes.
And in your contacts with Mrs. Menendez, apart from selling the house, did you also try to advise her or guide her in purchasing furnishings for that house?
Objection, relevance.
Sustained.
I take it you had never met either Lyle or Eric Menendez until after their parents died. Is that
That's
correct?
right.
Now, with respect, you called the family room the game room. Is that what you called it when you built the house?
Yes.
Okay, but that is the same room, the one with the bookcases.
Yes.
And was it your experience when you lived in that house that you could play a television set in that room without it causing a disturbance to any of the people, if there were people in the surrounding rooms?
Yes.
And was it your experience when you lived in the house that the maid's room also had a television that could be played without disturbing anybody in the family room?
Your Honor, assumes facts not in evidence, lack of foundation.
Rephrase the question.
When you lived in the house, was there a television in the maid's room?
Objection, relevance.
Overruled.
Yes,
Did someone use that television from time to time in the maid's room?
yes,
Were you at times when someone was watching television in the maid's room in the family room?
yes.
Could you hear the maid's room TV?
No,
Was it your purpose when you built this house to make it a house where there would not be disturbing noises going from one area of the house to the other?
yes. That room more purposely than others because it abutted the kitchen and the laundry room. So there was extra protection for that.
Which one are you talking about?
I'm talking about the game room,
So,
family room, and the bar area.
so you made that one extra soundproof because it would be close to working areas of the house?
Yes, it had a layer of 1 inch, in addition to the normal insulation and drywall on both sides. It had a layer of 1 inch rough cedar on it that would have made it, that much harder to hear through.
And adding the bookcases that made it even harder still, did it not?
I can only speculate to that because I didn't hear it after the bookcases were in, but it would seem to me that would be the
Your Honor,
case.
move to strike. It would seem to me as being speculation on the part of the witness.
Sorry.
Mr. Slotkin, when you did visit the house after the Menendezes moved in, did you see that the bookcase was in fact full of books?
Yes,
And trophies, is that correct?
I don't remember the trophies.
I have nothing further, Your Honor.
Mr. Slotkin, when did you purchase the property at 722 North Elm?
About 1982,
And when you purchased the property, was there a house on it?
yes,
Did you tear the house down completely?
except for a small portion of the basement, yes.
All right, so Exhibit 6 that's on the board that you've made reference to, does that appear to be similar to the blueprints that you submitted to the city of Beverly Hills when you built your house?
Except for the stairway, pretty similar, yes.
All right, and this particular blueprint, may I approach, Your Honor?
Yes.
This particular exhibit, number 6, would it be fair to say then that the house that existed on the property before you built the house did not have a staircase in this particular area here,
There was a staircase that went down to the basement,
in this area?
somewhere in that area to my recollection, but there was also a staircase that, and that's what I'm thinking that this one is, there was a staircase that was in the original blueprints that went up to the second floor and that was taken out. And that's what I'm referring to.
Okay, so the original blueprints that you submitted to the city of Beverly Hills to construct this property contained a staircase in this area next to what we call either the den or the study?
To go upstairs.
Yes.
Yes, that was taken out.
Well, I'm going to object, Your Honor. I think the question's vague as to which original blueprints are being referred to, of the earlier house or of the house he was building?
I indicated the original blueprints that you submitted to the city of Beverly Hills when you built your property after tearing down the other house. Did they contain a staircase going up in the area that's depicted on diagram 6 that you've said you never built?
Yes,
Okay. Now, I believe you've indicated that you spent some time in the maid's room. Is that correct?
yes.
Did you ever spend the night in the maid's room?
No.
Okay, now, I'm going to ask you some questions because I'm going to ask you some questions about noise in the house, and I'm not trying to pry Mr. Slotkin, but did you ever conduct any noise test? In other words, did you ever go stay in the maid's room to see if you could hear noise coming from other parts of the house?
No, I didn't conduct such a test.
All right, and were you ever aware of whether or not other people were having screaming fights in your house, and you were in another part of the house and you could either hear them or not hear them?
We didn't have screaming fights in our house, so I would say I was not aware of that.
All right, so you don't know how the noise traveled in your house if somebody was having some sort of screaming fight. Would that be fair to say?
Not about a fight, but about other things. You could hear televisions or not hear them, and you could hear pounding, like if you were hammering something and putting up a picture frame or something, you could, we were in construction. I was familiar with the two rooms.
Yeah, yes, but if you couldn't hear something occur, how did you know it occurred? In other words, if someone was up in another room of the house, let's say someone was in Eric Menendez bedroom and you were in the maid's bathroom, you wouldn't know if someone was conducting certain activities in another bedroom unless you saw it, right?
Objection argumentative.
Do you understand my question?
Yeah, if I didn't hear, you're saying if I didn't actually hear the fight going on, then I wouldn't be able to make an assessment of whether I could hear it or I couldn't hear it.
Right.
The only thing that I based that on was that when I lived in the house and I had guests or if somebody stayed in Eric's bedroom, you had to yell at the top of your lungs from downstairs to upstairs to get some attention. And, hey, come on down unless you use the intercom system.
Okay, but were you ever able to yell upstairs and get someone to come downstairs without using the intercom?
Not from the maid's room, no.
Well, how about from the foyer?
Yeah, you could get somebody to come from the foyer down there. They might hear you.
Now, did you ever go into the guest house and conduct any sound tests to see what you could hear from the guest house from the inside of the main house?
Excuse me, I think the question's a little confusing.
You understand?
Yes.
Okay. Did you ever do that? Did you ever go in the guest house to see what you could hear coming from the main house?
The guest house back by the pool, right?
Yes.
You could. Did I conduct sound tests from the guest house to the main house?
Correct.
No, I did not conduct sound tests.
Okay. And you built the guest house at the same time that you built the main house?
Yes.
Okay. I believe you indicated that shortly after you learned that Mr. and Mrs. Menendez had died, that you went by the property and made your first contact with Eric and Lyle Menendez. Is that correct?
Yes.
Do you remember which day it was? Was it the day that you learned that they had died or the next day?
It was within 2 or 3 days maximum of the time of the killings.
All right, so it was your understanding that the killings had occurred on a Sunday and you went by within 2 or 3 days of that Sunday, is that correct?
Yes.
Now, I believe you indicated that at that first meeting of the two defendants, that you indicated that you would give them, that you had some ability to give them business advice, is that correct?
Well, it wasn't that, I didn't use the word business advice. It was, that was not the appropriate time. I just said if they needed any help with anything, I'd like to try to help them.
Right, and in your mind, did that include giving them business advice if they so desired?
Probably so, yes.
And at any time in any conversations that you had with them after this first meeting, did you ever give them any business advice?
I think so.
And what kind of business advice did you give them aside from what you've told us about the automobiles?
Well, we talked about the tennis, I thought they should make a business out of that. And there was some discussions about an investment that Lyle wanted to make back east that I advised them about.
And what kind of investment was
I'm going
that?
to object, Your Honor.
All right, when you indicate that Lyle Menendez asked you about some investment back east, was that business advice?
Yes.
Objection, Your Honor.
Oh, sorry. Yes.
Did you ever give Eric Menendez any business advice that was particular to his concerns?
Yes.
And what kind of business advice did you give him? Excuse me, Your Honor, I believe this was done in front of both juries. What kind of business advice did you give Eric Menendez?
Aside from becoming a tennis player,
Yes.
Eric wanted to, this is later on, several months later, Eric was
Would
going to,
object, Your Honor. Irrelevance, that's several months later.
Eric was thinking about or had actually given some money to a friend of his to put on some sort of a concert.
Your Honor, I'd like to approach.
Skating for over 45 years has taken a toll on my body. I take Cunol turmeric because it helps with healthy joints and inflammation support. Why Cunol? It has superior absorption compared to regular turmeric. Cunol, the brand I trust.
Mr. Slotkin, did Eric Menendez make any inquiry of you about investing money in a concert? You can answer that yes or no.
Yes.
And did either Eric Menendez or his brother Lyle Menendez ever make any inquiry of you about whether they should invest in real estate? Was that ever discussed?
No, we didn't discuss real estate.
Did either of the defendants ever indicate to you where they were going to acquire the money to pay for their ventures?
I'm going to object to the form of the question. I don't know what ventures she has in mind.
All right, why don't you rephrase the question?
Did either of the defendants ever indicate to you where they were going to get the money to fulfill their business aspirations?
Same objection, Your Honor.
All right, overruled.
Yes.
And where did they tell you the money was coming from?
Well, I'm going to object also to the form of the question as to who is speaking.
Sustained.
Do you have a specific recollection of discussing the source of funds with either Eric Menendez or Lyle Menendez? You can answer that yes or no.
I thought it was both of them.
Okay, did you have, when you had your discussions with them, which concerned business affairs, was it always with both of them?
Pretty much so.
Okay, and what did both of them indicate to you as the source of the funds that they would be using?
We have the foundation at the time.
Yes, you can specify when it was.
All right, Mr. Slotkin, how many times did you meet with the defendants after the first time when you went by the house, where you spoke about things like money or business?
Maybe three to five times, but it wasn't only primarily business, but that's when I can remember that that entered into it.
All right, and when you had these 3 to 5 meetings with the defendants where that particular subject might have been brought up, where did these meetings occur?
Sometimes at my office and more often at my house.
And when you say your house, you mean something other than 722 North Elm, correct?
Yes.
And do you recall at one of these particular meetings that you became aware of where the source of funds was for these particular ventures?
There was some mention about a source of funds, yes.
And do you remember what month that was that you heard that mention?
I think it was maybe within the first 2 months.
Okay, and what were you told as to where the money was coming from?
There were several sources that they had mentioned.
Okay, could you tell me what they were, please?
The first was from a insurance policy. And the second was from Coralco.
And what did you understand Coralco to be from the defendants?
The employer of Mr. Menendez.
And what kind of monies were you told were going to be coming from Coralco?
What kind of monies?
Yeah, well, like how much are we, were you given an amount?
Somewhere enough, $4 or $5 million to buy the house for the boys.
All right, so it was your understanding that from Coralco, they would be receiving approximately $4 to $5 million?
Well, that's what the boys told me. I didn't know if that was a fact or not.
Right, I'm just
In
asking.
fact, I disputed that with them.
Okay, but you in fact, they told you that they believed that there would be approximately $4 or $5 million coming from the employer of Mr. Menendez.
Well,
Is that what they told?
May I amplify, or you just want a yes or no?
Well, okay, you can amplify.
They thought that Coralco, who had a key man insurance policy that they didn't even know about at the time, but discovered later on, was going to be that Coralco was going to turn over part of the proceeds of that key man insurance policy to the boys. That's what they thought.
Okay, so they had indicated to you that they did, prior to the deaths of their parents, they didn't know about the key man policy. Is that correct?
Yes. I
And-
don't believe they had knowledge of that.
Okay, and you specifically recall that. Is that correct?
Well, I didn't talk to them before the parents' death, so that's my
Is that your impression?
very, very, very strong impression that they did not have knowledge of that before the parents died.
All right, and so it was your understanding then that there would be some monies coming from Coralco, which were the result of a key man insurance policy?
It was the boys' understanding, and they led me to believe that.
All right. And was it, so you think the first time you were apprised of this particular policy was within 2 months of your first meeting with them in the driveway of the home? Is that correct?
Approximately.
All right. Now, did they have any further discussion with you about any other sources of money they expected to get aside from the insurance policy and the money from Coralco?
Well, that was an ongoing impression that they had about the Coralco thing that lasted for a lot longer after they discovered. They always thought that Coralco was going to come to their aid through this insurance policy. There was another insurance policy for considerably less money that I think was funded to them.
And when you say you think it was funded to them, is that because of something they told you or something that you learned outside of their telling you?
That's something that they told me, that they were going to be funded a smaller insurance policy.
And do you have a specific recollection that they told you that they were going to be funded from this smaller policy in the future? In other words,
at our first meeting 2 weeks after that, they felt they had a certain cash pool that was available to them through either the insurance or through the estate or something, and they were, they didn't want to just throw it away. They wanted to make sure that whatever they did with it was going to be wisely done.
did they ever tell you during any of these 3 to 5 discussions how much they thought the estate was worth?
Your Honor, I'm going to object to this. It's way beyond the scope.
Overall.
And I'm asking you specifically what they told you and not what you might have read in the newspapers.
I guess if you added up the two policies, that's what they thought they had, and the house,
All right.
whatever the equity in the house was.
Did the defendants ever talk to you about whether or not they knew or thought that they were going to be the heirs to their parents' estate?
Your Honor, I'm going to object to this. It's beyond the scope.
The question is vague as to time.
All right. When you met with the defendants the first time, which was approximately 2 weeks after you'd gone by the house, did you have any discussion with the defendants as to whether they thought they would be inheriting money from their parents?
Your Honor, I'm going to object that it's irrelevant given the time frame.
Overall.
Well, that wasn't the purpose of the conversation. You understand that there was some mention that they thought they were going to be the heirs of the estate. That's where they were going to get the money from.
All right. So
And they also had an uncle who was helping them.
okay, so your understanding was then that the first meeting they had with you, that the business advice portion of the meeting was not the predominant feature of that meeting. Would that be fair to say?
The first time I met with them, or when they came to my office?
When they came to your office the first time.
They just were lost souls and needed some friend and some help. And there was some, we didn't really discuss the money aspect of insurance policies, all that other stuff. I just try to put them on the course that they would, if they could be tennis players, they should be, because they would never get another opportunity as they grew older, and they should try to see if they had that talent or they didn't have it. And Eric should continue to go to school.
All right. And then during the course of that meeting, you also discussed their transportation needs. Is that correct?
They said they both needed cars. And I said, they said, what kind of car should we buy? And I said they should buy a car that isn't going to lose any money or very much money. And each of them had a preference. And I thought, given the insurance policy that was going to be given to them, that it wouldn't be an outlandish expenditure. And they asked me, and I told them that was okay.
All right. So you knew when you talked about the automobiles that there was going to be insurance money made available to them. Is that correct?
I really am a little confused whether it was insurance money or whether it was coming from the uncle, but there was some, cash of money that they knew that they were going to get.
And you indicated that each of them had a preference for the kind of car that they wanted. Is that correct?
Yes.
And what preference did Lyle Menendez express to
Objection,
you?
Your Honor.
Overall.
Lyle wanted a Porsche convertible.
And what preference did Eric Menendez express to you at that time?
He wanted a Jeep.
Okay.
A Jeep, one of those Jeep Wranglers, whatever they call them.
All right. And
The open air one.
And I take it you discussed with them the money situation and you determined that would be feasible. Is that correct?
I want to make sure they could afford it, and that was correct.
Okay. Now, on other occasions, aside from this first meeting at your office, did you have meetings with the defendants these 3 to 5 times, which centered more on business concerns than the meeting you just described?
No, I mean, they made the decision to go on to start working on their tennis and hire a tennis coach. They both went and bought their cars, and then a lot of it was centered around, personal activities. We played chess and, just had nice times together. And once in a while there would be discussion as to where they were going or what was going on. And they'd ask me a question and I'd help them.
Did the court, during this course of the time, when was the last time you saw them before they were arrested in March of 1990, if you recall?
Probably several days before that.
All right. How many times do you think you saw them in total between the time of the first time you met them in the driveway and the few days before their arrest?
Well, Eric more than Lyle, but cumulatively probably 25, 20.
And you would have seen Eric more times than Lyle?
Lyle was more back east, and Eric was here.
All right, and during that period of time, did either of the defendants ever discuss with you how things were going with the insurance policy at Carolco?
Maybe once or twice.
And who discussed it with you, if you recall?
Well, there was the boys and myself had always had a difference of an opinion about it. They thought they were going to receive something from Carolco, and I said, there's no way that Carolco is going to give you anything.
All right, now did they ever indicate to you that in fact they hadn't gotten any money from the company?
They never did that, to my knowledge.
Well, did they ever tell you we're not getting money from the company?
Um,
Or we still hope we are, or anything of that nature?
I think that the arrest cut that short.
All right,
So we never did hear that.
all right, and aside from the policy, the smaller policy and the money from Carolco, did either of the defendants indicate to you any other assets that they thought they would be inheriting?
This has been asked and answered, Julie.
Sustained.
Well, you indicated they thought that they were going to get the house in Beverly Hills, is that
Your Honor,
correct?
this was asked and answered.
It has been.
Well, did they ever indicate to you anything about the house in Calabasas?
Yes,
What did they indicate to you about the house in Calabasas?
that they had a house that was incomplete in Calabasas and was vacant and needed some more work on it. And that's what they indicated.
All right, and did they ever consult with you about doing the work since in fact you had built the house in which they had lived?
They consulted me about having the work done, not by me, but to have it done. And I just told them they should have it finished and get
And-
rid of it.
And
Sell it.
was it your understanding that they intended to sell the house in Calabasas?
Yes.
Okay, thank you. I have nothing further.
Redirect.
Now, Mr. Slotkin, you knew that there was a lawyer working for, you knew the uncle was an executor of the estates of the parents.
Yes.
And you knew there was a lawyer working for the uncle, working for the executors,
I talked to him, yes.
Mr. Goldberg.
I believe so, right.
And it was your understanding, wasn't it, that all this information that Eric and Lyle are getting about Carolco and negotiating with them is coming from the lawyer?
Objection. Calls for hearsay, Your Honor.
Sustained as to the form of the question.
Was that
Calls for
discussed
conclusion
with-
on the part of the witness.
That the first of all, were you told that the lawyer was trying to negotiate with Carolco to see if Carolco would buy the house?
Objection. Vegas to time.
Can you be more clear as to who the speaker was
By either of the brothers?
overall? Do you understand the question?
I think so. I understood that the boys weren't dealing directly with Carolco, that there was an intermediary, and that it was either the uncle or the lawyer.
And were the brothers telling you that they're being told by either the uncle or the lawyer that Carolco might be willing to buy the house because they had this big key man policy that benefited them?
Objection. Leading.
Overall.
Yes.
And you tried to dissuade them from that belief because you didn't think a business would be that generous. Is that correct?
Well, dissuade isn't really the word. It wasn't a question of persuading them one way or the other. I just told them that wasn't, I didn't think that was going to happen.
And they told you they were hearing other information from the uncle and the lawyer.
Yes. Excuse me. The reason that this came up, if there's any
Yes.
confusion, is because I had advised them that they should sell the house.
Right.
And they said that Carolco was going to buy the house from them. And so that's kind of how the whole thing came about.
And in fact, at the time they were arrested, as far as what you understood was there was still this thing going on between the uncle and the lawyer and Carolco, and the house had not been sold.
Objection. Leading and calls for hearsay.
Sustained.
Was it your understanding at the time that the brothers were arrested that as far as they understood, based on their based on your last conversation with either of them about this topic, close in time to when they were arrested, were there still supposedly discussions going on between Karolko and the uncle and the lawyer about Karolko buying the house?
Yes,
And to the best of your knowledge, Mr. Slotkin, the house had not even been put up for sale at the time that they were arrested. Is that correct?
I believe that's right.
Now, you said that they seemed like lost souls. Did you think it unusual that these two young men who were virtual strangers came to you for advice?
Objection, improper opinion.
Sustained.
Why do you think they came to you?
Objection calls for speculation.
Sustained.
Why did you call them lost souls?
Objection, irrelevant.
Sustained.
What was it about them that made you feel that they needed your advice?
Objection calls for conclusion on the part of the witness.
Sustained.
Had you had any conversations of any kind with Eric or Lyle Menendez? Your Honor, may we approach
On what subject?
mugging?
All right. If there has been any demonstrations by any counsel, both juries are admonished to disregard it. Any lawyer making any or having any reaction to any of the testimony is inappropriate and is, in essence, counsel reacting and arguing to the jury, and their chance to argue to the jury is coming up very soon. They'll be arguing to you next week, and at that point, they'll be able to express verbally their views on the subject. So at this point, the jury is admonished to disregard any reactions by any counsel.
Thank you, Your Honor.
Your next question.
I just want to clarify, Mr. Slotkin, this first time you ever talked to Eric and Lyle Menendez about any kind of investments or what they should do with their life or what was going on concerning the death of their parents was 2 weeks after, at least 2 weeks after the parents died. Is that correct?
Yes.
And it was at that time, it was 2 weeks after you met them?
I met them shortly after the parents died,
Correct.
and they called several weeks later to come down and see me.
So it could have been more than 2 weeks even later.
No, I don't think much more than that.
All right. Or about 2 weeks after you first met them.
I'm comfortable with that.
Okay. And at that time is the very first time you ever talked to them about any of these issues, about what they should do with their life, about what kind of money they might have access to in the near future, about things that the uncle and the lawyer may have been telling them. Is that correct?
That's right.
Did you give them any advice about whether or not the uncle and the lawyer was giving them good advice?
Objection calls for conclusion on the part of the witness.
You're asking, what did he tell them?
I'm asking if he gave them advice about that.
All right, objection overruled.
Yes.
Did they indicate to you that they were seeking advice from the uncle and the lawyer and seeking guidance from them as well?
They were listening to the uncle and the lawyer, but it was kind of a thing where the uncle and the lawyer had already taken over whatever was going to happen to the boys financially, and they questioned some of that, and we discussed it.
And did you advise them that you didn't think they were being well advised?
Well, I didn't say it that way. My big disagreement with everybody was that Karolko was not going to buy the house, so that they shouldn't rely on it. And they were of a very strong opinion that, being advised from their advisors that was going to happen. And I said they shouldn't rely on it.
Okay. I have nothing further.
Examination on behalf of Lyle Menendez.
Mr. Slotkin, do you still have the photographs up there?
Yes.
Showing you 399F where you have pointed to the maid's window which faces the outside. It looks in that photograph like it's a stationary window. Is that your recollection?
No, I believe the window opened.
And can you tell from that photograph whether it's a stationary window or not?
I really can't, and I'm really not sure, but
Do you have a recollection one way or the other?
I would think that it opened just because you would like to have the air, somebody be able to open the air up if they wanted to, but I don't have a definite recollection one way or the other.
Now, I believe you testified that in that first meeting with them at the house, right after the killing, that the subject of business was not discussed in any way whatsoever, correct?
The first time I met them?
Yes.
No.
And I think you said something indirect about fatherly advice. Did you use those words?
I just said that if they needed a friend or some sort of, father figure, because I'm twice their age, I'd be happy to help them if possible.
And then the meeting approximately 2 weeks later followed on that suggestion by you, correct?
Part of the meeting was that, yes.
And did they come into that meeting with an agenda of business items that they wanted to discuss with you?
Well, it was less formal than that, but they wanted to discuss their future. What would they do now?
And did they seem to have the sophistication that you did in business affairs when they came in at that time?
No.
You characterize them as being lost souls. What did you mean by that in reference to the business discussions that you were having on that?
Well, they didn't have a direction. Things had been so interrupted for them. They did not have a direction as to what they were going to do or with their lives or with anything. And they just needed somebody to sit down and impartially talk to them.
And that was your clear impression from that conversation 2 weeks after the killings, correct?
Well, that part of it. Plus, we were making friends and talking about people that we might know in common and so forth and so forth.
Thank you. That's all I have.
Any recross?
I have one question. Mr. Slotkin, did either of the defendants ever tell you that they killed their parents?
No, they didn't say that.
Thank you.
All right, you may step down. You're excused. Your next witness.
Take Mark Heffernan.
Somebody getting it?
One of my favorite supplements is Cunol turmeric. Turmeric helps with healthy joints and inflammation support, and Cunol has the #1 doctor recommended form of turmeric. Cunol, the brand I trust.
Mark C. Heffernan, Hefffernan.
Spell your first name, please.
Mark, M-A-R-K.
Mr. Heffernan, is your correct title Dr. Heffernan,
Yes, it is.
and you're a psychologist?
I'm soon to be a psychologist. I'm a psychological intern right now.
You know Lyle and Eric Menendez, is that correct?
That's correct.
When did you first meet them?
I met them, I believe, in the fall, the early fall of 1988.
And did you become their tennis coach?
Soon thereafter.
And were you coaching both of the boys?
I was coaching both of the boys. I started with Lyle and Eric followed, and then I pursued Eric more when Lyle went to school.
And were you still their coach in the summer of 1989 when their parents died?
Yes, I was.
And did they have any other coach at that time?
Not to my knowledge.
And at the time that their parents died, were you still employed as their coach?
Yes, I was.
You had not been terminated or given any indication that your services would not be needed in the future. Is that correct?
That's correct.
How often would you be at the Menendez home to coach one or the other of the boys?
I'd say 6 to 10 hours a week.
And were there times when the Menendez parents, one or both of them, would be outside watching the session?
Yes.
And I'd like to show you a photograph which has previously been marked as 387. May I approach, Your Honor?
Yes.
Dr. Heffernan, do you recognize the area depicted in that photograph?
Yes, I do.
There appears to be some lawn furniture, patio table and chairs, which are in front of the guest house. Did you see that?
Yes, I did.
And do you remember seeing this patio furniture in this location?
Yes, I did.
And would there be times when the Menendez parents would sit in that patio furniture at that table and watch the practice sessions?
They would.
And did you ever see a time when this table and chairs setup was moved into this walkway between the tennis court and the swimming pool?
Never the table, occasionally the chairs.
Would there have been room for the table to have been moved in that area?
I'm not sure. I don't remember seeing it there.
In all of the times you were there, did you ever see the table placed in this walkway between the tennis court and the swimming pool? Or was it in the place depicted in that photograph back at the guest house?
I would say it was back there.
During the times that you were working with either Lyle or Eric and the parents were outside, would the parents comment on the training that was going on?
Mr. Menendez would occasionally.
Okay, let me ask you first. Would Mrs. Menendez ever give instructions, make comments, interfere in the session in any way?
No.
Did Mr. Menendez sometimes?
Yes, he did.
And when he would make comments, would the boys respond using vulgarity or swear at him?
Not to my knowledge, no.
During all of the times that you were there, did you ever hear either Eric or Lyle Menendez swear at their parents?
No, I didn't.
Now, were there occasions when they would make a mistake on the court and they would be angry at themselves and express it verbally?
Absolutely.
Is that unusual?
No, that's very usual.
I can barely hear the witness.
All right, if you can move a little closer.
Sorry.
Now, when I say is that unusual, what was it unusual for them to have reacted that way, or is it, I'm sorry, let me start again. When I asked you about them making a mistake and getting angry at themselves and expressing it verbally, you said that was common, it was usual.
Yes, it was common.
And is it common among other players you've coached?
Yes, it is. Very competitive players tend to be hard on themselves. Mm-hmm.
And you played tennis for a good part of your life, is that correct?
That's correct.
And in your experience, both as a player and a coach, would you see this kind of behavior where people get angry at themselves and express it?
Often.
Were you with Lyle Menendez in July of 1989 in New York?
Yes, I was.
And were you there for some sort of a tennis tournament yourself?
Yeah, I was playing a national tournament at the U.S. Tennis Center.
And were you with Lyle Menendez when he bought a camcorder?
Yes, I was.
And did you discuss with him the purpose for which this was intended?
I think so. I think we were going to use it for tennis videoing.
Could you, perhaps you can move the microphone a little bit? No, we have to move it a little bit.
Oh, I can do that. Yes. That's great.
Mr. and Mrs. Menendez died on Sunday, August 20th. Do you remember being at the house sometime prior to that?
I remember being there Friday morning, I believe.
And were you there on Saturday?
No, I was not.
And do you have any specific memory as to whether there were plans for you to be there on Saturday or whether the family had other plans?
No, there was no plans for me. They were going fishing on Saturday, and we were going to touch base on Sunday. They usually touched base with me, so I didn't. They didn't call, so I didn't. I presume they had something to do on Sunday.
But you're sure you were not there on Saturday?
I'm sure.
And you have blonde hair, I notice.
I think I do.
Did you have blonde hair on August 19th, 1989?
I think I still did. Mhm.
Thank you. I have nothing further.
I have it on mine. This is correct. This is
Examination on behalf of Eric Menendez.
Mr. Heffernan, when you were in New York with Lyle Menendez, you believe that was July of 1989?
I believe it was.
And you were with him when he purchased this camcorder to use it for tennis?
Yes.
And you would use it for tennis by recording what you're doing and then be able to look at the video and improve your game and work
Yes.
harder at it.
Leading.
Is that right?
Overall.
Is that how
Yes,
you
that's
use it?
correct.
Where was Eric Menendez when you and Lyle were in New York together?
I can't remember.
Was he in New York?
He was not.
And did you understand as Eric's tennis coach that that summer he would be competing in a number of tournaments around the country?
Yes.
Did you see him, in fact, over the course of that summer until after the tournaments were over?
I did see him. He was traveling, and in between traveling, he'd be home, and we'd work on his game and prepare him for tournament play.
So you'd see him in between the tournaments back home?
Yes.
I have nothing further. Oh, wait, I do have one question. You understood from working with Eric and Lyle since the fall of '88 that as of the summer of '89, you were the only person who was coaching. Is that right?
Yes, I believe I was.
And you would have known if they were working with another coach, wouldn't you?
Objection calls for speculation.
Sustained.
In your experience, if one of your players has other coaches, isn't that fact discussed, or you can figure it out from how they're playing?
Objection calls for speculation. It's irrelevant.
Overall, you can answer the question.
I believe it would have been discussed. I have clients currently that work with coaches, and I, as a sports psychologist, I know the team that's involved.
Okay. And did you know when you were working with Eric that in years past, there had been times when he had multiple coaches?
Yes.
The tennis court behind the Menendez home, is it a north-south court or an east-west court?
East-west.
And with an east-west court, does that cause part of the court to go into shadow at different times of the day?
It does. It's more that the sun's in an interesting angle. It's a little more challenging to play there in late afternoon.
Yeah, especially if you're facing west. Is
Yes.
that correct? Okay. Have you?
Your Honor, I have one question.
All right, sure.
Mr. Heffernan, when did you first learn that Lyle Menendez had a hairpiece?
I think throughout this trial proceedings.
Thank you. I have nothing further.
Cross-examination.
Thank you, Your Honor. Mr. Heffernan, who paid for the lessons for these men, these defendants?
Mrs. Menendez usually paid. I think it came from Jose's business account, I think, if I remember correctly.
And what did they pay per hour for lessons?
Your Honor, I'm going to object to this in front of my jury because this witness has already testified to all this in front of the jury.
Overall.
$55 an hour.
And you indicated that on Friday, that would be August 18th, 1989, you gave a lesson to the defendants. Is that correct?
I gave a lesson to Eric, I believe, in the morning.
Now, do you recall when that lesson was given?
Your Honor, I would object to this as asked and answered during
Overruled.
the case.
Overruled. I believed it was 9:30 in the morning, 9 or 9:30 for a couple of hours.
So 9:30 until 11:30?
Yes,
And that's Friday, correct?
Friday.
How do you recall that particular date? Was there something that was discussed between you and defendant Eric Menendez about the next day being a Saturday?
I believe that they said they were going fishing and they wouldn't be available on Saturday. But that's all I remember.
Do you recall talking to Eric Menendez and telling him or being told by him that he would call you on Sunday?
I believe,
I'd like to approach that.
overruled. I believe that was the plan. He was going to call me
I
on.
object to the people re-examining the same way.
Overruled. Overruled.
What was your answer, sir?
I believe that he was going to call me if we were going to have a session on Sunday, and
Now, you said that you were with Lyle Menendez in New York in July of 1989. Is that correct?
it is correct.
Do you know when that was? Was it early July?
I'm not, I think it was the first week in July. However, I could be mistaken. It was a tournament that I had to play, one of the national tournaments, and I'm not sure the date. I can't be sure.
Your best recollection is it was the first week in July?
I think so.
May I approach, Your Honor?
No,
What do you have in your question?
Nothing, I'm just going to approach the
picture.
Heffernan, would you take a look at this photograph depicting the guest house and the pool, and to this side would be the tennis court? How did you get onto that court? How would one go onto the court to play tennis?
There was a gate, I believe, in the middle of the small fence as you walk further down.
Okay, when you say the small fence, would that be in the center
Yes.
area of this photograph?
Yes, it would.
So there was an open area?
Yeah, there was an open area. I think there was a small gate. It was open all the time.
And you had seen chairs over in the area between the pool and the tennis court where the parents would watch the defendants play tennis?
Yes.
And would the parents watch the defendants play tennis quite a bit when you gave lessons?
Jose would come out when he was around, and I was there at the same time he was. Usually he would come out. Kitty came out far less, and neither of them came out a lot. I taught them in the daytime, and Jose was working. And if he had a business meeting in there, I would carry out my business, and he wouldn't see it.
So on the few occasions that you actually saw the parents out in that area, there was no argument, no yelling and screaming between the defendants and their parents?
No, not on the court.
No cussing?
Not toward the parents. I never heard the parents cuss at the boys either, so.
Now, when you say you didn't notice arguments on the court, did you notice arguments between the parents and the brothers off the court?
About petty things, occasionally with, I think Kitty would say, you have to do this, and the boys would be mad. I think relatively harmless family squabbles.
Would you ever hear the brothers cuss on the court in the presence of their mother when she was out in the backyard watching the lessons?
They would have had to make a very bad shot.
Okay.
Very bad. I can't really recall that, to tell you the truth.
Now, you indicated that they would get angry at themselves often on the court and they would swear. Is that correct?
I wouldn't say often, but it happens for sure if you're trying hard and you're not getting the results that you would like.
And so that would happen occasionally when the parents were out in the backyard watching them in their lessons.
Yes.
Is that fair to say?
That'd be fair to say. Mm-hmm.
Now, you've indicated that you weren't at the Menendez home on Saturday, August 19th, correct?
That's correct.
Are you aware that there were other players that played with the Menendez brothers in their backyard.
Objection, Your Honor. Assumes facts, not in evidence.
Rephrase the question.
Okay. Were there other players that played with the defendants in the backyard on their tennis court?
Yes, there were.
You weren't with them all the time.
No, I was not.
They would have to get some pretty high caliber players to play against them because they were pretty good tennis players, weren't they?
That's correct.
You don't know where they were on Saturday during the afternoon on the 19th of August, do you?
I assumed they were fishing. That's what they said they were going to be doing. I'm not sure what time of day on Saturday that was happening, but Saturday they were fishing.
Did they indicate to you that they were going to go fishing in the late afternoon on Saturday?
I can't remember the time, to tell you the truth.
Here, I have an American Express statement. May I have this marked next to it? I believe it's 400.
Your Honor, we're going to object to this as beyond the scope.
It'll be marked exhibit 400 and,
Did we see it?
Yes, I've shown it to council previously.
You haven't shown it to Miss Lansing, Mr. Kuriano. She's never seen it. I'd like to approach.
that's first, witness, All right, would you want to approach it?
No, that's not necessary. Then. I'll hold off on this for the blue draft.
There'll still be an objection at this point.
Let's proceed.
Nothing further this time.
Any redirect?
Mr. Heffernan, did you have a playbook by which you would keep track of your appointments in 1989?
I did for my students in general.
Yes.
Yes.
It was both a calendar and a way of noting their progress and what you were working on with them.
I wouldn't have that in the same book.
Okay. Did you have a calendar book that told you when you were
Yes.
teaching? And you no longer have that book, is that correct?
That's correct.
Now, was there any reason why you, I'll strike that. Did you, when you were coaching Eric Menendez and Lyle Menendez at their home, were there certain days of the week when you would never coach them, or could you see them on almost any day?
I could see them on almost any day. It
So
was
you
random.
you would teach on Thursdays just as easily as on Fridays,
Yes.
is that right? And you say your best recollection is that you gave this lesson on Friday morning, is that correct?
That is correct.
And you realize that Eric's best recollection is that it was on Thursday morning. Did you know that?
I didn't know that.
Okay. Do you have any way of being absolutely certain what morning it is without your calendar?
Absolutely certain, I'd have to say no.
But you do recall, do you not, that you didn't teach that weekend because you knew about the fishing trip and you were supposed to be called if you were needed for a lesson on Sunday?
Yes.
I take it if you first learned that Lyle wore a hairpiece during trial, Eric never mentioned it to you during all the time that you coached him.
Objection calls for
Is
hearsay.
that correct?
Beyond the scope.
Well, it's argumentative as phrase. You may rephrase the question.
Okay. Eric never mentioned to you anything about Lyle having a hairpiece, did he?
Objection leading calls for
Rephrase the
hearsay.
question.
Did Eric ever mention to you anything about Lyle having a hairpiece?
Objection calls for hearsay.
Overruled.
No, he did not.
And you saw Eric, what, 3 or 4 times a week?
I would say that's fair on an average.
And besides being his coach, you were also, even then, involved in sports psychology?
Yes.
And was he close to you?
I would think he would be close to me.
As closest to anybody?
I'm not sure about that. I think he was closer to his friends, but
All right. Did you know Jamie Pisarcik, Lyle's ex-girlfriend?
yes, I did.
Beyond the scope.
Sustain.
Skating for over 45 years has taken a toll on my body. I take Cunol turmeric because it helps with healthy joints and inflammation support. Why Cunol? It has superior absorption compared to regular turmeric. Cunol, the brand I trust.
Can I have one moment?
Yes.
I have nothing further.
Anything else? Right. Mr. Priyama, anything else?
Mr. Heffernan, do you recall testifying in this court on August 13th, 1993?
Yes, I do.
And do you recall testifying,
Could I see?
yes,
Here.
page 11,071?
Excuse me, I have copies.
Okay.
I'm passing that one down. Wait just a minute.
Sure.
11,000.
11,071. Starting at line 10.
Wait just a second. I'm going to object, Your Honor's improper impeachment, no foundation. It's not inconsistent.
Yes, it is.
Should I show does the court want?
Yes, why don't you show it? All right, the objection is overruled.
Thank you, Your Honor. May I approach a witness, Your Honor?
Yes.
I'm sorry, is there a reason?
I assume he's going to show him the transcript, is that it?
Mr. Heffernan?
Being shown to refresh his recollection, is that the idea?
Yes. To take a look at this page, 11,071, starting at line 10, down to the bottom of that page. Finished?
Yes, I think so.
Mr. Heffernan, do you recall testifying on August 13th, I believe it was, in the fashion as indicated on 11,071?
I don't recall, but I see that I said that, so
Okay. Does that refresh your recollection as to what it?
yes.
Okay.
Mhm.
Now, do you recall being asked by Mrs. Abramson, was it something about that last coaching date before the parents died that makes you believe it occurred on Friday? And you answered yes. She then asked August 18th.
If he remembers, he can be asked the question. He doesn't
Overall.
have to read it.
Overruled.
Mrs. Abramson asked August 18th. You answered yes, there was. The question then was, would you tell us what that was? And you replied, I was seeing what their schedule would be for the weekend. And he said, well, we're not going to be taking a lesson tomorrow because we're going fishing with our parents. That was your statement, correct?
Correct.
And Mrs. Abramson then asked, this is, Eric said, I can't take a lesson tomorrow, which would be Saturday, and you answered yes. Next question, because we're going fishing with our parents, and you answered, and I believe he said he would call me on Sunday to let me know what we are doing for either the rest of the weekend or next week. Is that correct?
I guess it's correct.
Thank you.
Mr. Heffernan, 4 years later, can you be sure that what Eric said was tomorrow versus Saturday?
When I originally thought of this, I think that I believed that I taught him on Friday. And I guess as the trial's gone on, my memory is fading. So I guess I have to go on what I've said in the past. That's closer to the events.
Would you believe it, but you can't be absolutely sure because you don't have a calendar to show you.
Yes, I cannot be absolutely sure.
That's all. Thank you.
Anything else?
Nothing further.
All right, thank you. You may step down.
Thank you.
Your next witness.
Your Honor, the next witness would be Les Peckins. We need to get a piece of equipment. May we just have a moment? I think we
Sure.
Let's get.
There's going to change.
We have a witness from just the gold jury.
All right.
Be very brief.
Okay, then we'll, as far as the blue jury is concerned, we'll recess until 1:30. Don't discuss the matter with anyone. Don't form any final opinions about it. And we'll see you back here at 1:30. And the gold jury would stay, please. Why don't you go tell them that? Still, huh? Yeah. All right, let's proceed. Your next witness. If you would step forward and face the court clerk and raise your right hand, please.
You do solemnly swear that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Please take the stand and state your name for the record.
My name is William Janago, and that's spelled Genego.
Mr. Janago, what is your present occupation?
I'm an attorney.
And where did you get your undergraduate degree?
At New York University.
And where did you go to law school?
I went to Yale Law School
When did you graduate?
in 1975.
And did you then go on to get a graduate degree in law beyond that?
Yes, after receiving my Juris Doctorate at Yale in 1975, I then continued with my legal education at Georgetown University and received an LLM degree in 1977.
And during the time that you were at Yale Law School, were you the editor of the Law Review?
Yes, I was one of the editors of the Law Review. That's correct. The
Yes.
Law Journal, actually, it's called.
And since graduating, besides practicing law, have you been a professor at various law schools?
Yes, I have.
And which law schools specifically have you taught at?
I was a professor at the University of Southern California Law Center for about 8 years, and I also was a professor at Georgetown University, and I've also taught at UCLA Law School and Boston University Law School at various times.
And during the time that you were in private practice, have you worked both as a prosecutor and as a defense attorney?
I did practice for a period of time as a prosecutor, and I've also practiced as a defense lawyer.
Did I ask you to review the testimony of a witness in this trial?
Yes, you did.
Okay, and was that Miss Jamie Pizarczyk?
That's correct.
And did I direct you particularly to some testimony she gave with regard to looking up cases in the law library?
Yes, you did.
And is it basically her testimony?
Yeah, I object to this as being argumentative form.
We haven't heard the question.
Was the testimony I asked you to review that part of her testimony in which she indicated that she looked up cases in the law library in which children were accused of killing their parents and had claimed sexual abuse and had gotten off, been acquitted, or found not guilty? Is that a fair summary?
Your Honor, I'd object to this. That testimony speaks for itself, and I'd object to it as calling for a conclusion on the part of the witness.
Without characterizing exactly what the witness said, in general, did you review that portion of her testimony?
Yes, I did.
And was there something about the idea of someone looking up cases where someone gets off or is acquitted or is found not guilty, which stood out to you?
Yes, there was.
And why was that?
Because in a criminal case, when a defendant is acquitted by a jury, the case is never reported because there's no appeal. And so there would be no case reporting an acquittal of a defendant who had killed their parents.
Okay. Now, directly to your left up on the bench, Your Honor, could you hand him just the two books that are there?
All right, we'll give you one here.
Okay.
It should work.
And what do you recognize that to be?
This is the official California reports.
And what is that?
This is a volume of a series of volumes that are published, which contain written decisions of appellate courts. And when lawyers say they go to the library to look up cases, they go to a volume such as this to look at reported cases that are written by appellate courts.
Now, I've put a piece of paper up on the board next to you. And I would ask if you could approach there. Could you just draw for us what happens to cases once they get out of the trial court?
Sure.
And show where they go from there.
This is going to be marked as Exhibit 401.
That would be fine with me, Your Honor. Now, is it fair to say that all cases that are tried start out in the trial court, such as what we have here?
That is correct. And if we wanted to start with a trial court, let's say we could.
That's right, put it way at the bottom of the chart, that's okay.
I'll put it in capital letters.
Okay.
Yeah. Is it fair to say that some cases that come out of the trial court result in acquittals or not guilty verdicts?
Yes, that's right. If you had a not guilty verdict, let's say, that would be, let's say, a not guilty verdict. That would not go up on appeal because the defendant is found not guilty and the state is not allowed to appeal, and therefore that case would be off to the side, let's say.
And would it be published in law books such as you've referred to here?
No, the only cases which are published in law books are those of appellate courts. And since this is a trial court and not an appellate court, the verdict of not guilty would not be reported in those books.
Okay. Now, would you indicate on the chart the cases where there are guilty verdicts?
If the defendant is found guilty, let's say we'll have another box up here. That defendant would appeal, could appeal, has the right to appeal, and then that would go up to the first level of appeal in California is the Court of Appeal. And there's various courts of appeal that sit in the state of California. So a defendant who is found guilty has the opportunity to appeal his or her case to the Court of Appeal, whereas the defendant who's found not guilty, that case is never appealed. When the Court of Appeal decides the case, they write an opinion. They address legal issues, and the written opinion addressing those legal issues are contained in volumes such as that one. Now, after the Court of Appeal, a defendant also has the option of petitioning the California Supreme Court to review his or her conviction. And when the California Supreme Court, if they agree to hear the case, decides it, they too would write a written opinion addressing legal issues. And when that opinion is written, it would be reported in a book such as that one there. And then finally, a defendant has the option, if he has certain types of claims, of trying to get his case to the U.S. Supreme Court, which would be the final level of appeal. And again, if a defendant had his or her case heard by the U.S. Supreme Court and they were to write an opinion, that opinion would again address legal issues and would be written in a book such as that.
Okay.
And then finally, a defendant has the option, if he has certain types of claims, of trying to get his case to the U.S. Supreme Court, which would be the final level of appeal. And again, if a defendant had his or her case heard by the U.S. Supreme Court and they were to write an opinion, that opinion would again address legal issues and would be written in a book such as that.
Okay. Could you, before you resume your seat, just draw a few diagonal lines across Court of Appeals, California Supreme Court, and U.S. Supreme Court to show which types of cases would be published in the books? Thank you. So I take it the trial court opinions would not be published. You would not find to be not guilty cases.
That is right. They are not contained in a case report.
So if someone says they went to a law library to look up cases where defendants got off, were found not guilty, or acquitted, that's an impossibility. Is that correct?
There are no such cases.
Thank you. I have nothing further.
I have
Cross-examination,
at least 15 minutes. Do you want to do it?
15 minutes.
I think so, yeah.
Okay, then we'll do it at 1:30. Don't discuss the matter with anyone, ladies and gentlemen. Don't form any final opinions about it. We'll resume at 1:30.
Skating for over 45 years has taken a toll on my body. I take Cunol turmeric because it helps with healthy joints and inflammation support. Why Cunol? It has superior absorption compared to regular turmeric. Cunol, the brand I trust.
Defense to what they anticipate my cross-examination is going to be, which is why I gave the court those 2 volumes to read, to look at.
Perhaps so I don't respond to something that isn't going to happen. Maybe Mrs. Menendez can indicate what she intends to do.
I intend to talk to the witness about the fact that these 2 cases, which predate Mr. Menendez's incarceration, contain facts outlining specific facts dealing with child abuse. These are cases where I believe in one of the cases, the defendant was found guilty of a lesser offense. And I just wanted to discuss with him that this kind of information is available in the advance sheets to counter the kind of things that he said in his direct examination.
What things are in the advance sheets?
Well, I think, did the court see my notation, that first paragraph?
I read what you said I should read, yeah.
Right, okay, well, I was just going to make reference to those, and I'm also going to make reference to the fact that cases have synopsis in front of them. Because I believe Ms. Pizarzik testified that there were some synopsis that she read, and that's one of the.
Why do you have to show him particular cases to do that?
Well, to do the synopsis, I don't. But in terms of the particular fact situations in the 2 cases I gave the court, without going in depth, I was just going to ask him leading questions to the effect of that these cases do contain fact situations dealing with people killing their parents.
Well, unless these cases were actually seen by the defendant, it's kind of hard to justify showing those particular cases. I doubt very much if the witness would deny that there are such cases reported, and that there are cases where people have been charged with murder and found guilty of manslaughter, where a defense of child abuse in some fashion was proffered by the defense.
And in fact, I just showed him those 2 cases, so he could certainly answer the question now.
I would be surprised if he disputes that. I don't know why you have to show him particular cases.
Well, just as circumstantial evidence that those cases exist. I mean, we're not talking theoretically anymore. Here
no,
they are.
Depending on how he answers, I don't see any reason to show particular cases. Yes.
It's our position that the extent of his testimony was that if you get acquitted, there aren't appeals, and there are not cases that are published.
That's true, but Ms. Pizarczyk's testimony was not quite that clear that it was an acquittal that she was referring to. At some point in the examination, you asked that, and she said it, but she also used the word get off, and get off could mean found guilty of a lesser included offense.
Well, I would ask the court to look particularly.
I remember her testimony, and I was listening carefully when she answered, and she used the word get off, and then later on, you asked about acquitted or found not guilty, and she affirmed that in some fashion, but she used the phrase get off.
If I could, Your Honor,
Yeah.
just to cite the court and counsel to 22-460 of the transcript and the next 3 pages following, in which she uses the term get off, acquitted, and not guilty, a total of 11 times. And I asked her specifically a question. All of those cases were about kids who got off because they were sexually abused. That's what stands out in my memories reading specific cases. When you said got off, they were found not guilty. They were acquitted because of this. Is that correct? Answer correct. Correct question. And all of the cases were of the type that the kids were acquitted because they claimed sexual abuse when they were charged with killing their parents. Then later on, 22-461, question, but now you're very clear that these were kids who were acquitted. Yeah, well, if you read something like that, I would say a red flag would go off in your head. It did with me. I went, whoa, surprising. Then on 22-462, I said, are you aware that there are no published cases of children charged with killing their parents who claim sexual abuse and who are acquitted? She says, well, no. And I said, but you said they were acquitted or found not guilty. And she says, well, that's what I remember. And I said, but you remember specifically they were found not guilty. And she said, that was the context of the defense. Yes, so, I mean, we went through it as many times as humanly possible. It was acquitted and not guilty.
Yeah, that's all exactly as I remember it and as I recited it to you.
Okay, and that is what she's testified to. And this witness is merely coming to say that if people are acquitted, there are no published cases. Now, it would be our position that it's beyond the scope of the direct, even to go into, are there cases where people are found guilty of lessers such as manslaughter? And specifically would be beyond the scope to go into any other specific cases and the facts of them.
As I said, I don't see any reason to go into the facts as long as the witness affirms that there are such cases, which we all know, that they found guilty of lesser offenses. I can't believe that he would say otherwise. As I said, the specific cases shouldn't be gone into because there's no showing that the defendant saw those specific cases that have been shown to the court. So after this colloquy, we're at the same point as what I said before.
I think is that it with the 402?
I'm not sure what the black law dictionary reference was going to be. Get off.
Get off isn't in here.
To find it there.
No.
Can I inquire about the cross-examination of the black law dictionary?
I'm just going to ask him if it's in there. That's all.
Get off?
Yeah. Your Honor, I think I should be permitted to conduct cross-examination.
I'm not disputing that.
Okay.
You folks asked for a hearing outside the presence of the jury. I'm here giving you the hearing.
Okay. It was kind of obvious when I came in with all these books. So the only other thing, Your Honor, is we're going to need a 402 before they complete their case today because they want to play the KABC tape, and we're going to object.
We would rather just stipulate to it.
Your Honor, we offered
No.
a stipulation that on a certain date in August, Grant Walker.
Well, if you're working out some stipulation, I don't want to hear about it.
No, Your Honor, I'll stipulate to foundation, but not to relevance. If it's relevant, then I'll stipulate to foundation. I'm saying it shouldn't be played at all. That's the problem. Okay?
Okay. Anything else now before we resume? You have this witness, and then do you have another witness before this jury, or are you ready to go? How long will that next witness be?
5 minutes.
Okay, then let's have the gold jury.
What did you do with my?
Let's have the gold. Well, let's first of all.
Sprint records, the telephone stuff.
How long is the cross-examination going to be of this witness?
It'll be at least 20 minutes, I think.
Okay, then let's allow the blue jury to take a break. They've been in the jury room here since 1:30, so let them out until a quarter after. And then we'll have the gold jury come in. So the blue jury is excused until 2:15. Zoom with the examination of the witness. Cross-examination.
Mr. Janego, I believe you indicated that you're a lawyer, correct?
That's correct, yes.
How many years did you have to go to school after you graduated from college to become a lawyer?
3 years.
And at the completion of that 3-year period, did you have to take any kind of exam to be licensed by any state to practice law?
Yes, I did.
And what is the name of that exam?
Most people refer to it as a bar examination.
And does the bar examination last anywhere from 2.5 to 3 days in most states?
Depending upon where you take it, yes, that's correct.
And if you don't pass the bar exam, you cannot practice law in a state. Is that correct?
That's correct.
Okay. So you need 3 years of schooling. And is that full-time schooling?
It depends the state that you're going to ask to be licensed in. I think that certain states, for example, California, one does not need to attend law school at all, and you can still take the bar exam under certain circumstances.
Okay. And in order to do that, you have to take a certain series of tests, correct?
That's correct.
Known as the baby bar.
That's correct.
Okay. Now, you reviewed the testimony of Ms. Pizarczyk, correct?
That's correct, I did.
Did you see any signs in there that Ms. Pizarczyk had gone to law school?
No,
Did you see any signs in there that Ms. Pizarczyk had passed the bar exam?
no.
And do you remember the first mention in the transcript where Ms. Pizarczyk used the term got off or gotten off?
No, I don't remember the first time that you used that phrase.
May I correct the witness, please?
Yes.
129. Mr. Senego, showing you volume 129, referring to page 22,267. You see there at line 27, her answer, the cases were situations where children had gotten off after killing their parents. Do you see that term?
I do see that, correct.
Okay, that term gotten off, you're familiar with it as regards to Ms. Pizarczyk's testimony, correct?
Do you mean, did I read it where she used it? Yes.
Yes.
That's
okay.
correct.
I'm showing you what's called a Black's Law Dictionary. Do you recognize this particular kind
I
of
do recognize Black's Law Dictionary, yes.
And this is a dictionary that defines legal terms, correct?
Yes.
Okay, and this is something that you can find in almost all of the law libraries around the country, correct?
Correct.
Okay, I'm going to open up to the G's and ask here, do you see the term gotten off in the Black's Law Dictionary?
Not unless I'm spelling it incorrectly.
All right, so it doesn't appear in the Black's Law Dictionary, correct?
No.
Now, why does a defendant, a criminal defendant, appeal his case to a higher court in the trial court?
You're not going to get close to
In general, you're asking not in a specific case, just generally why?
Yeah, generally. Okay, when a let me just leave. When a defendant gets convicted of a crime, many times that defendant will go to the next level, to the Court of Appeals, correct?
I don't know what the exact percentage is. A number of defendants do choose to appeal their convictions. That's correct.
All right.
Some don't.
Well, if they don't choose to appeal their conviction, then that wouldn't appear in the law books either, right?
That's correct. If someone does not appeal their case, that would not result in a written opinion, and there would be no case reported.
Okay, so the only people who appeal their convictions are people that choose to do so, right?
There are some circumstances in which there are automatic appeals, but barring those few situations, the overwhelming majority of criminal appellate cases are those in which the defendant makes a decision to pursue an appeal, correct?
And in pursuing the appeal, he's trying to get the Court of Appeals to do something for him, correct?
Yes, he or she is ordinarily trying to get the Court of Appeal to do something.
I don't mean to be sexist. So he or she goes to the Court of Appeals because they've been convicted of an offense and they want the court to give them something, right?
I don't know what you mean by give them something. They would like the court to render a decision that's favorable to them, I suppose, if that's what you mean.
And if the decision is favorable to them, that will result in them getting off, right?
No.
Well, when the Court of Appeals renders a decision, they don't find someone not guilty, do they?
No, it's not the job of the Court of Appeals to make a factual determination of guilt or innocence as an initial matter. That's correct.
And courts of appeals do not use terms like we now find the defendant not guilty. That doesn't happen, does it?
That's correct. That does not happen.
And the Court of Appeal doesn't say we acquit the defendant either, do they?
there might be some very rare circumstances, not in California, but some in other jurisdictions where for reasons of insufficiency of the evidence as a matter of law, there might be a situation in which a phrase such as that would appear in opinion, but I think I would agree with you that ordinarily that phrase would not be found in an appellate opinion, correct?
And when a defendant goes to the Court of Appeal, he is seeking some sort of way to get his conviction overturned, correct?
For the most part, I'd say that's correct, yes.
Well, would you agree with me that most defendants do not appeal their case so that the court can tell them that the trial was fine and you're going to stay in jail, right? Most defendants don't do that.
No, but there are circumstances in which people appeal their convictions because they disagree with the amount of time that they got or a sentencing issue, and that could be something that would not going to result in them getting off in any way or getting out of jail, and still they would do it an appeal.
Well, if somebody has a sentencing problem and they think the judge sentenced them to too much time and the court agrees with them, then they could in fact be released because the court can reduce the amount of time they're going to do, right?
I think what would happen in those circumstances, other than a jail credit issue, as in most appellate proceedings, it would be remanded back to the trial court and there'd be a new proceeding, probably a new sentencing at that point. So no, the person would not be released at that point.
No, but the person would be released as a result of the actions of the Court of Appeals.
No, I disagree.
Well, if the Court of Appeals says you gave 2 sentences when you only should have given 1 under Penal Code Section 654, for instance, then that could result in an immediate reduction of sentence once the person's sent back to the trial court, right?
If the person has already served the time that's remaining on the other sentence, sure.
All right. Now, when a person goes to the Supreme Court of the state of California and appeals their criminal conviction, they're going there so the Supreme Court will somehow let them go. I mean, that's the ultimate goal, isn't it? Is to let them go.
No, actually, I think that probably the overwhelming majority of criminal appeals result in a remand for another trial. The defendant doesn't get off because of an appellate decision. What happens is that they say there is some error in the initial trial and they send it back so that there can be another trial. The appellate court doesn't release the person.
And well, no, the appellate court doesn't, because the way it works is the appellate court sends, as a matter of procedure, the body of and the case back to the trial court, correct?
That's correct.
All right. And sometimes when a new trial is granted, the people can't proceed because the witnesses are gone or something like that, and the defendant's released, right?
I would object to speculative.
Sustained.
Okay. Are you aware of cases in which people get new trials and the state can't proceed against that person because there are no more witnesses?
I would object.
Sustained. This is also irrelevant.
Okay. Mr. Janego, are you aware of the fact that there are cases in the books like the one the judge showed you this morning where people are found guilty of lesser offenses?
Yes.
Okay. Would you describe to the jury, because you're a legal expert, what a lesser offense is?
A defendant can be charged with a variety of different crimes. Some of them are more serious than others. And a jury may decide that a defendant should be acquitted or found not guilty of a particular charge, but still might find that there's sufficient evidence of guilt on another charge, and for that reason, acquit a defendant of one charge and find the defendant guilty of another charge.
For instance, in a burglary case, they might find the defendant guilty of second-degree burglary versus first-degree burglary, correct?
That's correct.
And therefore, the defendant has been acquitted of first-degree burglary because by virtue of the conviction of the second-degree burglary.
That's correct.
Likewise, in a murder case, if a person is charged with first-degree murder and is found guilty of voluntary manslaughter, then that person has gotten a lesser offense, correct?
They've been convicted of a lesser offense than what they were initially charged of, correct?
All right. And in that particular situation, the person has been found not guilty of first-degree murder by virtue of the fact that they were found guilty of voluntary manslaughter, correct?
Well, that's not necessarily true. I mean, that wouldn't have to be the case. It might be that a jury would reach that decision, but they might just return a verdict on the lesser included, or it might be some lesser charge in the charging instrument. So it wouldn't necessarily mean that the jury would also find an acquittal with respect to the other charge.
Mr. Janego, if the defendant is charged with first-degree murder and the jury finds him guilty of voluntary manslaughter, then he has not been found guilty of first-degree murder, has he?
He has not been found guilty of first-degree murder. That's correct.
Okay. And to a layperson, that might appear to be getting off, mightn't it?
I'm going to object to speculative.
Sustained.
Okay, now, did you ever ask Ms. Pizarzik what she meant by the term get off?
I've never spoken with her.
All right. Now, you're aware of the fact, are you not, that there are published opinions in books such as the one that the judge showed you, where defendants use a child abuse defense in order to justify their actions in a homicide case. Are you aware of that?
Overall. Do I have personal knowledge of any such cases, or do I believe such cases exist?
Well,
or do I think it would be possible that such a case could exist?
well, do you think it's, no, do you know that such cases exist?
I don't have personal knowledge of any such case now.
All right, are you aware of the fact that child abuse is currently used as a defense to homicide in many parts of this country?
Yes.
And if a person uses child abuse as a defense to homicide and is found guilty of voluntary manslaughter and not first-degree murder, that person has gotten off the first-degree murder charge, correct?
It depends how you use the term gotten off. A person who was convicted under those circumstances could still face a lengthy time in prison because of their conviction of the manslaughter charge. And would that be getting off? I don't think so.
Well, I guess it's from the point of view of the person who's going to do the time, isn't it?
That's one perspective. I suppose other people would have different perspectives.
All right. Are you aware of the fact that when cases are listed in these books, that oftentimes the particular facts of the case are listed? In other words, Joe Blow went to a bar with a gun and blew away one of the patrons. Do you understand that these cases contain very specific facts in them?
Yes, that's
All right.
correct.
And is it also true that at the beginning of the cases, at least in California, there's what's called a synopsis of the case, where there's usually 2 paragraphs which sum up the rest of the case, correct?
That's correct.
All right. And those 2 paragraphs, one of them tells you what happens in the trial court, and the second paragraph tells you what the Court of Appeal or the Supreme Court did, right? Generally.
Generally speaking, that's probably correct. I don't know if there's any specific format that's used in every case. I think it changes occasionally, but there is a summary which contains the basic information of what occurred below, and then also what the decision of the appellate court is.
Now, when a person goes to law school and they're learning about the law, what do they read?
Many things.
Do they read cases?
One of the things they do read is reported cases.
And when you teach in law school, do you have your students read reported cases?
Yes,
And is that how people can, was that one way by which people can learn about the law?
that's one way people learn about the law.
Okay. And these cases which contain the facts, they also contain legal theories. Is that correct?
They contain appellate judges' discussions of legal theories.
And that's one of the major ways that law students are taught about the law, right?
There's something that's known as case books that professors use, which contain excerpts of those cases in them that they use for instructional purpose, correct?
And in fact, many of those cases that we have to read in law school, you have to read from beginning to end. Isn't that correct?
If you want to understand them completely, yes.
Your Honor, I'm going to object that this is beyond the scope.
Well, it is getting far afield, so let's.
That was my last question in that area.
Okay.
Now, when a defendant goes to a court of appeal and asks the court to do something, there are several things the court can do, correct?
Yes.
Okay, one of the things the court can do is reverse the case, and that's the end of the case, correct?
Reverse the case?
In other words, the defendant's been convicted of something, and the court can reverse the case, such as cases of insufficiency of the evidence. And then the case is over, right?
There could be a situation where an appellate court could find that the prosecution has not introduced sufficient evidence to meet its burden of proof. And for that reason, find that the prosecution's evidence is insufficient as a matter of law. And that would be the end of the case. That is theoretically possible.
Well, that's happened. I mean,
it does happen.
And therefore, the defendant who gets a reversal from the Court of Appeals or the Supreme Court has gotten off, correct?
Yes, but in those circumstances, what happens is that the prosecution's evidence is determined to be insufficient as a matter of law. It's not based on the convincing nature of a defendant's proof. So it's not as a result of a defense that someone case ends at that point in the appellate court. It ends in the appellate court under those rare circumstances where the prosecution, as a matter of law, has not introduced enough evidence to even warrant a conviction.
Are you telling me that in those particular cases, they never discussed the defense at all?
They might.
All right. And in those particular cases, then the defendant would get off, correct?
That's correct, if the
All right.
prosecution did not submit a sufficient case.
The other thing is the Court of Appeal could reduce the charges. In other words, the Court of Appeal might decide that the charge with which the defendant was convicted is too much or too high, and the court could reduce that charge to a lesser charge, correct?
There are very strict legal rules which govern an appellate court's authority to alter a jury's verdict in that way, but there are circumstances in which, again, they could find that the evidence as a matter of law was not sufficient to support a finding on a particular charge, and find that it was sufficient to support a lesser charge or a different charge, and therefore affirm the conviction on that charge but not affirm it on the other charge. That's correct.
So, for instance, if the court reduced a first-degree murder conviction to a voluntary manslaughter, then the defendant would then have suffered a lesser conviction by virtue of the Court of Appeals action, correct?
That's correct.
Okay. The other thing the court can do is reverse the case and send it back for a new trial, correct?
That is correct.
And that's one of the things we've discussed already.
Yes.
Okay. And the other thing the court can do is say, no, the conviction's fine. We're just going to leave it where it is, correct?
They can affirm the conviction. That's correct.
And in almost all of the situations where a case is taken to the Court of Appeal and it ends up in a book like the one that you had before lunch, the facts of that case are almost always discussed. Is that correct?
Yes.
Okay. Now, there are several ways by which a defendant can get into the Court of Appeals. For instance, after a criminal conviction, he can end up there because he's appealing his conviction, correct?
That's correct.
There are also ways by which the prosecution can appeal pretrial rulings, correct?
Yes.
In other words, there would be perhaps a motion to suppress evidence which was granted, and the prosecution appeals that.
There are limited circumstances in which the prosecution can appeal before the trial has begun certain legal rulings. That's correct.
And there are other cases where a defendant's case is dismissed on what's called a 995 motion and the people appeal.
That's correct.
And those are cases where the defendant has already gotten off and then the people appeal the judge's ruling, letting that defendant go, correct?
Prior to trial, yes.
Okay. So there are a number of ways in which a court of appeal or the Supreme Court can benefit defendants, correct?
Yes.
And to a layperson, those benefits might be construed as getting off, correct?
Again, it depends on what you mean by getting off. If the person's conviction is still affirmed, they're still doing a substantial time in prison, whether that's getting off is debatable. But I suppose to the extent that some people might read that as some favorable actions for a defendant, even though the defendant is still going to do a long time in prison, that might be getting off, I suppose.
Well, you would agree, would you not, that doing a life term with no parole is a lot worse than doing 6 or 8 years in state prison, correct?
Yes.
All right. Thank you. I have nothing further.
Any redirect?
Yes, Sean.
Mr. Janego, you read Ms. Pizarsik's testimony, is that correct?
Yes, I did.
And she talked about getting acquittal and about getting acquitted or being found not guilty, is that correct?
Yes, she specifically said not guilty. That's right.
And she talked about cases in which children are charged with killing their parents and claim sexual abuse as a defense.
Yes, I believe
Is that correct?
Testimony. Yes.
Now, Ms. Pizanich asked you if there are pretrial rulings that could end up in the Court of Appeals. Is that
Yes.
correct? She asked you such as when the prosecution could appeal a 995,
That's correct. She did.
or when the prosecution could appeal a ruling on a search issue.
That's right.
Now, in those cases, would there have been any defense presented?
No, none whatsoever.
So there would be no cases that would fit the facts that Ms. Pizarzik referred to, which is children alleging child abuse. They would fit into the category she's referred to. Is that correct?
That's correct.
So if we're taking, strike that. The cases in which the prosecution can appeal would occur before any defense was presented.
That's
Is that correct?
They would occur prior to trial, and they would occur before any defense was presented. That's right.
So there would be no cases such as she has described here in that category that would come anywhere near what Ms. Pizarczyk is referring to. Is that correct?
That is correct, yes.
Now, she's asked you about situations in which the Court of Appeals or the Supreme Court would reverse the case and the case would be over. And you talked about where the evidence just wasn't sufficient.
That is correct. An appellate court does have the authority, under very limited circumstances, to find that the prosecution's evidence, as a matter of law, the prosecution's evidence was not sufficient to support a conviction. And for that reason, terminate the case at that point.
Is that extremely rare?
It's very, very rare.
And she also asked you about a situation in which the Court of Appeals can reduce the charge, which is go to a less serious charge. Is that correct?
Yes.
Is it true that the most common situation that you're going to see in cases that are appealed are that the cases are sent back for new trial?
The overwhelming majority of appellate cases are affirmed, but even in those limited cases where a defendant receives something favorable from an appellate court, what it generally is a remand, or the case is sent back from the appellate court back to the trial court for a new trial. That's correct.
Now, you were asked extensively about whether getting off, what the meaning of getting off would be. And I think you indicated that's subjective. To somebody, getting a lesser charge could conceivably mean getting off.
Depends how the individual is using that term. That's correct.
And Mrs. Bazanich specifically referred to getting 6 or 8 years as getting off.
Yes.
Do you have any reason to believe that someone who got convicted of manslaughter would only get 6 or 8 years?
No, in fact, the legal term that's authorized is much longer than that. A person who's convicted of manslaughter can do much longer in prison than that.
And when you read Ms. Pizarczyk's testimony, did it appear to be clear that she was talking about people who at trial were found not guilty?
For conclusion on the part of the witness.
I didn't quite hear the question. Can I have it read back? Or why don't you just re-ask it?
If I can, Your Honor.
All right.
Directing court and counsel to page 22-460, starting at line 26. When you were reviewing the transcript, did you see the question that said, when I asked Ms. Pizarczyk, when you said got off, they were found not guilty. They were acquitted because of this. Is that correct? And she answered, correct. Do you remember seeing that?
Yes, I did read that portion of the transcript.
And I asked her later at 22-461, you're very clear that they were acquitted. And she answered, well, yeah, if you read something like that, I would say a red flag would go up in your head. It did with me. I went, whoa, surprising. Do you remember reading that?
Yes, I do remember reading that.
And do you remember my asking her, are you aware there are no published cases of children who are charged with killing their parents who claim sexual abuse and are acquitted? And she said, maybe the ones law was asking me to look at were appealed cases. I don't know. And I said, but you said they were acquitted or found not guilty. And she answered, well, that is what I remember. And then I asked, but you remember specifically they were found not guilty? And she answered, that was the context of the defense. Yes. Is that what you recall?
Yes, I remember reading it.
Do you remember her saying anything about having their sentence reduced?
No.
Do you remember her saying anything about having the charges reduced?
No.
Mrs. Bazanich asked you about the summary that appears at the beginning of a case.
Yes.
Is it true that that summary almost always starts out, defendant was convicted of X?
Generally speaking, that's the way most of those summaries begin. That's correct.
Do you remember reading any case that came out of a trial court that said defendant was acquitted? Is that the way they begin?
No, they do not begin that way.
So the reference is always to what crime it was they were convicted of.
That's correct, because only the defendant can appeal the conviction. That's correct.
So if someone is reading, a layperson, someone who's not trained in the law and is reading through the summary of the cases, the first line that's going to jump out at them is that the defendant was convicted. Is that correct?
That's correct.
Thank you. I have nothing further.
Anything else? All right, now let's see you at the sidebar here.
Skating for over 45 years has taken a toll on my body. I take Cunol turmeric because it helps with healthy joints and inflammation support. Why Cunol? It has superior absorption compared to regular turmeric. Cunol, the brand I trust.
Mr. Janego, you came here to testify because you have special knowledge about the law that Ms. Pizarza does not possess. Is that correct?
I don't know if that's why I came here to testify. I think that I have certain knowledge about the law that she doesn't have. That's a fair statement.
And you're here as a legal expert, isn't that correct?
Yes.
Okay. Now, do people appeal convictions even when they've been found guilty of lesser offenses?
Yes.
All right. So, for instance, if someone were found guilty of, let's say, involuntary manslaughter, they might still appeal that conviction even though they were charged originally with murder, correct?
That's correct.
Okay. I believe you indicated that when there are pre-trial appeals by the prosecution that the defense would not be presented in the written opinions published in the advance sheets. Is that your testimony?
I think what I testified was that a defense would not have been presented at that point in time. And for that reason, the opinion would not ordinarily discuss a defense because none had been presented.
Except that if there was a defense presented at a preliminary hearing, then that defense might be discussed in the advance sheet, correct?
It's possible, although it's very unlikely because the 995 motion would deal with the sufficiency of the prosecution's evidence. That's the legal determination that's being made at that point.
Yes, but if in fact there was a defense presented at the preliminary hearing, then the defense would be part of the discussion of the facts of the case in the 995 appeal, correct?
I suppose that's theoretically possible depending upon what kind of defense it was, because the kind of defenses that one could present at a 995 or at a preliminary hearing motion are limited in and of themselves.
May I approach please with the transcript?
Of what?
It's 130, volume 130.
All right.
What page? Page 22460. And you notice here the question that was asked of you by Ms. Lansing, starting at line 26. Do you see here that the question was by Ms. Lansing to the witness, when you said got off, they were found not guilty, they were acquitted because of this. Is that correct? So those were Ms. Lansing's words. Is that correct?
If you represent to me that's what that transcript is, I take your word for it, yes.
Do most lawyers know legal terms better than most civilians?
Yes.
That's why they went to law school, right? To learn all those legal terms?
I don't think that's why they went to law school.
Sustained.
Further.
Right, anything else?
Just briefly. Mrs. Kazanchik's references to the 995. Is it in felony cases, are there generally hearings that are held without a jury before the trial to see if the people have enough evidence to go to the next level?
That is correct.
And that's called a preliminary hearing.
Yes.
And if you have a 995, it is someone evaluating the sufficiency of the people's evidence at that preliminary hearing. Is that correct?
Right. Prior to the trial, if it's a case in which there's a preliminary hearing, that means without a jury, the prosecution presents its case, and there's a legal determination at that point as to the sufficiency of the prosecution's proof. If a defendant disagrees and says that the evidence is insufficient as a matter of law, there's a penal code section, and it's section 995, which authorized him or her to ask for review of that legal decision about the sufficiency of the prosecution's evidence.
Is it extremely rare that you would find any case of this nature in the law books to begin with?
Yes.
And is it even rarer that there would have been any defense presented?
Yes, it would be even rarer. And again, as I mentioned before, during cross-examination, the kinds of defenses that one can present at a preliminary hearing are limited in and of themselves.
And people are not acquitted or found not guilty in this kind of a setting, are they?
No, they're not.
And it's not called a trial, is it?
No, it is not.
So if someone talks about having a trial and people getting acquitted or found not guilty, they wouldn't be talking about this very rare circumstance you're talking about called a 995. Is that
No.
correct?
Judge and call for speculation, you expect the answer.
Sustained answer, sir.
That would not be an appropriate term to use. Trial would not be an appropriate term to use under these circumstances. Is that correct?
There would have been no trial, so it would not be an appropriate term to use.
And so if someone was looking at a published case of a 995 of that nature, words such as trial would not appear in the opinion. Is that correct?
That's correct. To the contrary, the Court of Appeal would make it quite clear that it was judging the sufficiency of the prosecution's case on a 995 motion prior to trial.
Mr. Janego, if I may take you right back to the very beginning, would you in the law library find cases of people who had gone to trial, been charged with killing their parents, claimed sexual abuse as a defense, and been acquitted?
No, you would not.
Thank you. I have nothing further.
Anything else?
No, you're not.
All right, thank you. You may step down. You're excused. Thank you. Your next witness?
Is Tim Custer. I'll go down. Tim Custer.
All right, if any of the blue jurors want to come in, we can let them in at this point as well. Sure. All right, if you would step forward, sir, and there's some people behind you who want to get through as well. All right, just move in here a little bit and let people go by. All right, would you raise your right hand, please?
You do solemnly swear that the testimony you may give in the cause of action before this court to be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
Please take the stand and state the name for the record.
Timothy Custer,
Spell your last name.
Custer.
Mr. Custer, do you know Lyle Menendez, who's seated here to my right?
Yes, ma'am.
And how is it that you came to know him?
I do some ministering at the county jail, and I went one Sunday and took some Bibles for him and his brother to visit.
And have you done that before in other jail-type facilities where you go and see people who are locked up and talk to them about religion?
Yes, ma'am.
And did you make visits of that nature to both Lyle Menendez and his brother Eric on a
Yes.
number of occasions?
Yes, ma'am.
Did you, during the course of your visiting with Lyle and his brother Eric, come to know a woman named Jamie Pisarcik?
Yes, ma'am.
And what was her relationship?
Lyle's girlfriend.
Were you there when, in the fall of 1990, when something unusual happened?
Yes, ma'am.
And what was that?
It was the day after she had received the ring that Lyle had given her.
The engagement ring?
Yes, ma'am.
And did you know Miss Pisarcik well enough to talk to her at that time?
Oh, yes. She knew me by name. Yes, ma'am.
Now, were you actually in the visiting area when she and Lyle discussed the ring or the engagement, or did you have a conversation with her after she came out?
After she came out, I was waiting out in the waiting room.
Okay. And what did she say to you? How did she seem? Let me start with that.
She was real happy, joyous, jovial. She was showing the ring and told me that Lyle had proposed to her. And she was just real happy. And she said, and everyone was laughing. I believe her mother was there. She was like behind her or, aside of her or something. And she said that Lyle had proposed to her and he'd gotten down on his knees behind the petition there where you visit them. And she was, laughing about it because she said some of the inmates were teasing him about it because it's something that doesn't happen every day. So.
And did she seem happy about it?
Yes.
Thank you.
Yes, she was real excited.
I have nothing further.
Cross-examination?
No, thank you.
All right, thank you, sir. You may sit down. You're excused. And who is the next witness?
The next.
It would be before both juries,
Yeah.
Your Honor, and
Oh,
it depends on who's out there.
okay. Why don't you see if, let's also check on our jurors and see if we have all our blue jurors back.
Can I check on my phone?
Yeah. Yes, and we'll have the bailiff check on our jurors.
Yes.
Two, Your Honor.
All right, do we have any blue jurors outside? Okay. All right, let's take a recess then and let everybody get back in here. We have some blue jurors who have yet to return. So we'll take a recess and we'll resume at 2:45, ladies and gentlemen. Don't discuss it with anyone. Don't form any final opinions about this case, and we'll resume at 2:45. You may call your next witness.
Thank you, Your Honor. We would call Mr. Peckins. Step forward, sir.
Raise your right hand. Do you solemnly swear that the testimony you may give in the cause held pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please take the stand and state your name for the record.
My name is Les Peckins,
Spell your last name, please.
Peckins.
All right, you may examine the witness.
Thank you, Your Honor. Mr. Peckins, what is your occupation?
I am a part owner of a company called Habeas Copies, which is a litigation support company.
And as part of your business, do you provide services for lawyers who are in trial and need various graphic displays and other items?
I do for lawyers, law firms, and the courts.
And are you familiar with the video that has been marked Exhibit 402 and which is presently in the video player that you have in front of you?
I am.
Okay, and have you seen that video before?
I have.
Okay, did you in fact cause the video to be made?
I did.
Did you work the camera yourself or did you have somebody else do that?
No, I had a camera person with me.
Okay, were you present at the time the camera person shot the video?
I was.
And you are familiar with the contents of the video, is that
I am.
correct?
Yes.
Did you, in essence, direct the video?
You might say that, yes.
Okay. Now, I'm also going to ask you to look at an exhibit that's been previously marked as 200. Do you recognize that exhibit? It's up on the board.
Yes, I do.
And did you, in fact, prepare that exhibit?
I did.
Is that exhibit a blow-up of certain documents you received from the city of Beverly Hills?
It is.
And is that a map of the roughly 700 block of Elm Drive and Maple Drive in Beverly Hills?
Yes, it is.
Does the exhibit that's been marked 200 depict some of the places that you shot in the video?
Yes.
Okay. Do you have a control that would enable you to play the video now?
Yes, I do.
Your Honor, before he begins, should we move?
Yes, I think.
All right, yeah, if anybody in front of the jurors there, that would be a good idea. You're probably wondering why they didn't do that about 3 or 4 months ago. All right, you may proceed.
Thank you. Would you press the play button, please?
Oh, okay, fine.
Okay, could we press pause for a minute, Mr. Peckins, while our juror? Okay.
Everyone see pretty much? Okay.
Let me ask you before we begin, does this video begin with a northbound trip on Elm Drive?
It does.
Okay, could you play the video? May I approach, Your Honor?
All right, you have some new batteries?
I don't know how much help I can be.
Time froze.
Doesn't seem to want to move.
Oh, maybe? Ah,
Oh,
Okay.
of course. You have to press the pause button again.
Marcia. Congratulations. He's on.
could you press stop now? Or pause, thank you. Mr. Peckins, we've just seen a drive northbound on Elm Drive in Beverly Hills, is that
Yes.
correct? Is that on the same side of the street as 722 North Elm Drive?
Yes, it is.
In fact, you've stopped the video just as you are approaching 722 North Elm Drive, is that correct?
That's right.
And that appears to be a white house with some greenish colored gates in front of it?
Yes.
Okay, could you back up the video just a little bit? Okay, that's fine, and now started. There appears to be a house that has a blue Rolls Royce or Bentley, some fancy type car.
I
you see that house?
believe it was a Rolls.
Okay, and is that car parked in the driveway of the property immediately next to 722 North Elm Drive?
It is.
All right. Could you stop the video now? Okay, I think we have to go back a little bit. I'm looking for the house that is just north of 722 North Elm. Okay.
Oops.
Okay, now back just a little bit more. It's acting up today. All right. Is that the house?
It seems.
Was that the house just of 722 North Elm?
It was.
Okay. And I'm going to try and ask you one more time if you can back up and show the jury the relationship between the house to the north of 722 and 722, if you can, if the machine will cooperate. I guess it's not going to.
I'm pressing rewind and it doesn't seem to want to do that.
Okay, let's stop right there. Is that a close-up of the front door of 722 North Elm Drive?
It is.
Okay, and you can you see, in fact, that the front door in that close-up?
Yes, the brownish colored through the trees.
And where were you standing, Mr. Peckins, when that particular shot was made?
Just about in the middle of the thoroughfare, in the middle of the street.
In the middle of the street. So
Yeah.
that is what can be seen from, in fact, the middle of the street. Is that correct?
Yes.
And could you give us an estimate or approximation of the distance between the actual front door of the residence and the sidewalk in front of 722 North Elm?
Oh, I would say approximately 20 yards.
Okay. And could you, well, let's continue with the video and then I'll ask you. Now, right now, are you kind of circling around with the camera, starting at 722 North Elm and then going in circle?
No, we are starting across the street from 722 and panning 360 degrees, and you'll see we'll go by 722 right there.
In fact,
and,
there's the
and continue,
Rolls Royce, right?
yes, and continue panning around.
Okay, could you stop the video there? There is now on the screen a house with some pillars. Is that correct?
Yes.
Is that a house at 718 North Elm Drive?
It is.
Directing the attention to Exhibit 200, which is the map. Can you see 718 North Elm Drive on that map?
Oh, can I? Yes.
Yes.
I'm sorry, yes.
And in fact, does it appear to have the word Krom, K-R-O-M, written on
It
718?
does. Yes.
Now, 718 is a house that is there's a house in between 718 and 722 North Elm. Is that
That's
correct?
right. Yes.
And that is the house that has the bluish colored Rolls Royce in the driveway. Is that correct?
The house in between the two, yes.
Yes. Okay. Could you play the video again, please? All right, let's stop the video now. Where is that shot taken from?
This is
Now, Your Honor.
This is really very bulky. It doesn't want to obey.
It just doesn't, huh?
No, it just doesn't want to obey.
Well, I guess maybe it's hitting the eye or something.
I should be aiming it at the VCR rather than at the.
Okay, we just had a shot of an alley, right?
Yes,
Where is that alley?
that is behind 722 and all of those houses. There is a narrow alley, a public thoroughfare that runs behind those houses.
Miss Lansing is going to assist us.
Not with the machine.
No. Now that is, we just saw a shot of an alley directly behind 724 North Elms Drive. Is that correct?
Yes.
Okay. And Ms. Lansing, could you see if you could find that on the
724.
right? Okay, so that would be the alley directly behind.
That's
Also,
right.
Ms. Lansing, would you point out the 718 again, the Chrome residence, which is one with the pillars? Thank you. All right, let's.
Menendez.
Menendez says Menendez. Okay. All right. Now, what do we have on the TV screen now, Mr. Peckins?
This is directly behind 722. And although I can't see, and my best guess would be that it's a lighted tennis court.
Okay, so 722 North Elm has a tennis court as well?
As I say, I could not see in, but I saw the lights, and the house at the beginning of that street has a lighted tennis court in much the same area, and so I just surmise that that's what that is.
Okay, let's see if we can get the video to play.
Okay.
And we're now showing houses which are in the alley in the vicinity of the rear of 722 North Elm Drive. Is that correct?
Yes, on the other side, and not, but this is now back on the same side.
Let's back up for a minute if we can. Okay, is this, let's, whoops, stop and we'll go forward. I'm trying to get to the back, the guest house at 724 North Elm Drive. Okay, you, in fact, appear in the video pointing at a building, is that correct?
Yes,
Is that the guest house at 722 North Elm Drive?
I believe that's what it is. It is an outbuilding,
Okay.
which,
And that is a building which is directly on the alleyway.
yes,
Is that correct? Perhaps
That's correct.
Ms. Lansing can locate that building on Exhibit 200. Would that be the approximate location of that
yes.
building? Okay. All right, let's play the video. That appears to be a two-story building. Is that
That's right.
accurate? All right, let's stop. We have part of the two-story building at the rear of 724 North Elm Drive, and there is a tennis court directly to the right of that.
Yes,
There appears to be a walkway that is also pictured in the middle of the television screen.
yes, but it's impossible to see in there. So I suspect that's what it is.
Okay, and is this a walkway which goes to the property at 724 North Elm Drive?
It's 724?
Yes,
No,
Is that
that's on the side of,
that's a different one.
that's a yes.
Okay.
That's on the side of 722.
Let's continue with the video. All right, is there another walkway shown there?
Yes,
Where is that walkway?
that's on the side of 724.
And is that a walkway that leads into the property at 724 North Elm Drive?
It would appear so, but again, the foliage is very heavy there, and so it was very difficult to see.
Is Miss Lansing pointing to the approximate place on the map where that walkway?
Oh, I'm sorry, you're talking about 724. No, this is between 722 and 720. This is on the other side.
Okay. All right, let's continue with the video. So what we're looking at now is the actual property line really between 720 and 722 and 720. Is that correct?
That's correct.
Are the properties fairly close together at that point?
They are.
So that previous scene shows the gate from the 720 property and the guest house on the 724.
That's right.
Now what are we looking at, Mr. President?
This is on the other side. This is the 724 side.
Okay. Now, what is seen in the video now?
That's the roof and the top story of 722.
Okay.
And this is along the side street to the north.
And that is another shot of 722?
This shot is 724 in the left-hand corner there.
Okay,
Is 724, the upper story of 724.
let's stop it there. Where you can see the white tile house is 722, correct?
Oops, I'm sorry, I pressed the wrong button.
Okay. At least they're responding.
Yes. Let's move. Okay. That's 724 on your left-hand side.
On the left-hand side.
Yes.
Okay, and that shows the relationship between 724 and the house next door, correct?
That's right.
Okay, could you continue with the video? And could you stop it? Can you see in that video, actually in the background, the actual house at 724?
In the background is the house at 722. In the foreground is the house at 724.
Okay. And approximately how close are the houses together at that point?
difficult to say precisely, but I would say it looked to me like about 10 or 15 feet.
Okay. All right, let's continue, if you will. All right, now we're back at the front of 722 North Elm. Is that
That's right.
correct? Mr. Peckins, when I asked you about the distance from the front door to the street, from the front door of 722 to the street, you estimated 20 yards. Now that's about 60 feet. Is that accurate?
I think I said 15 to 20 yards. It's perhaps a little less than that. Perhaps it might be as few as 10.
Okay. In any
But
event,
somewhere in that general vicinity.
in any event, that is a measurement taken when you're standing in the middle of the street, correct?
Yes.
As opposed to on the sidewalk.
Yes.
All right. Thank you. I have nothing further at this time.
All right, any other examination by other counsel? All right, thank you, sir. You may step down. You're excused. Your next witness.
My next witness is Cynthia Erdely.
Okay, has that tape recording been marked as an exhibit?
Yes, it has, Your Honor.
And the exhibit number?
402.
Your Honor, should we move this now? Move it out?
Yeah, if you could.
Skating for over 45 years has taken a toll on my body. I take Cunol turmeric because it helps with healthy joints and inflammation support. Why Cunol? It has superior absorption compared to regular turmeric. Cunol, the brand I trust.
Cynthia Erdely, Erdely.
Ms. Erdely, you previously testified and identified yourself as an investigator for the defense in this case. Is that right?
Yes.
As part of your duties in investigating this case, did you contact and interview a person named Grant Walker?
Yes.
And on how many different occasions did you interview Mr. Walker?
3.
And do you remember the dates of your interviews with him?
August 19th, 1993, September 9th, 1993, and November 22nd, 1993.
Now, with respect to your interviews of August 19th, 1993 and September 9th, 1993, were those conducted before he testified?
Yes.
And the last interview on November 22nd, was that after he testified?
Yes.
With respect to the first 2 interviews before he testified, did he ever mention to you in the course of those interviews that he had told Leon Bartek anything about having seen the Menendez brothers playing tennis at their home?
No.
And with respect to that the earliest interview on August 19th, during that interview, did he tell you that, did he state to you that he had called the Beverly Hills Police Department the Wednesday after the killings and talked to a desk officer who took his name?
Yes.
Now, did you also, when you spoke to Mr. Walker on November 22nd, did you ask him for the names of the 3 people who he claimed to have serviced pools for on Saturday, August 19th?
Yes.
And what 3 names did he give you?
Ann Ingraham, Mr. and Mrs. Chin, and Virginia Valdry.
Now, did you locate the Chin residence?
Yes.
Without giving us the address, was it in the 400 North block of Lucerne?
Yes. I'm sorry, I need to look at my report.
Okay, it was on Lucerne, correct?
On Lucerne, right.
It was on the 500 South block, wasn't it?
Sustained.
Look at your report.
Let's see. Okay, my report indicates the 500 block.
Okay, south?
Correct.
Okay. In fact, did any of the three families, Valdry, Ingraham, or Chin, reside in the 400 North block of Lucerne?
No.
Now, you interviewed Mrs. Valdry, did you not?
Yes.
On how many occasions did you interview her?
1 interview and 2 follow-up calls.
And what was the date of the formal interview?
Monday, November 29th, 1993.
Now, this is Mrs. Valdry, okay?
Correct.
All right. And did you ask Mrs. Valdry if indeed Mr. Walker serviced her pool on Saturday, August 19th, 1989?
Yes.
And what did she tell you?
Her answer was that he did not start working on Saturdays until 2.5 or 3 years ago.
And did you, in talking to her, pin down the earliest time it could have been that he started working on Saturdays?
Yes.
And what was that time, according to her?
Approximately 3 years ago, or approximately November or fall of 1990.
Now, when you, strike that, did Mrs. Valdry ever tell you that Mr. Walker strike that. Did Mrs. Valdry tell you what day of the week Mr. Walker worked for her before he started on Saturdays?
Yes.
And what did she tell you?
Her recollection was that it was a weekday, but she could not name the specific day of the week.
Was it the same weekday, though, each week until he switched to Saturdays?
I recall asking her if that weekday varied, and her answer was no.
So it was the same weekday until it became Saturdays?
As far as I understood from her, yes.
Now, did she ever tell you that he only worked a weekday in order to get the chlorine level right in the pool, and then he switched to Saturdays?
I'm sorry, I don't understand the question.
Okay. Did she say to you, oh, he only worked weekdays at the very beginning until he got the chlorine level in the pool stabilized?
Not to me, no.
Now, she did tell you that he started to work for her in 1987, correct?
Correct.
And is it true that based on the information she gave you, the impression she gave you was that he worked on a weekday for 3 years until he switched to Saturdays?
That was my understanding, yes.
Now, after you interviewed Mrs. Valdry, did you ask her if she would voluntarily come to court?
Yes, I did.
And at first, did she agree to do that?
Yes.
And then what happened?
Monday evening, after I last talked to her and asked if she needed directions or transportation.
It reflects the witness's state of mind, Your Honor. Her statements are not being offered for the truth of them.
Which witness's state of mind?
Mrs. Valdry's.
As to, well, let me see it sidebar here.
Okay, Ms. Ridley, you were telling us that you had a conversation with Mrs. Valdry. Was this the night before she was supposed to come to court?
Correct.
And what did she indicate to you that night before she was supposed to come to court?
That she would still be coming in voluntarily.
And was she requiring transportation be provided to her?
No.
All right. Now, did you then discover subsequently that she had failed or was refusing to come to court voluntarily?
Yes.
And did you then cause a subpoena to be served on her to require her attendance in court?
Yes.
And did you have contact with her after the service of the subpoena?
Not telephonically, not until I saw her again here in court.
Okay. And was she happy about having been served with a subpoena and being forced to come to court?
No.
In fact, was she angry?
Yes.
All right, the answer is stricken.
Did she express anger to you?
Yes.
And in fact, even after she was subpoenaed, did she call and indicate that she wasn't going to come?
Yes.
And was she told that if she didn't come, a warrant would be sought?
Not from me. No, I didn't have that conversation with her.
To your knowledge, did one of the other investigators have that conversation with her at my direction?
Sustained.
Did you communicate to another investigator working for the defense that she should be admonished that she had to come?
Sustained.
Did she show up after, well, first of all, did you report to me that she was threatening not to come even though she was subpoenaed?
Sustained. Objection sustained.
Did you see Mrs. Valdry after the time when she indicated she didn't want to come to court after she was subpoenaed?
Yes.
Was she angry?
Yes.
Now, did you interview Leon Bartek?
Yes.
And do you recall when it was that you interviewed him?
September 1st and September 9th, 1993.
Now, did you talk to Mr. Bartek about when it was that he discovered that the spa controls at the Menendez home were being overridden by the pool controls?
Yes, I did.
And did he indicate to you that he may have made that discovery 2 Wednesdays before the killings?
Yes, he did.
And did he tell you what day of the week it was that he serviced the Menendez pool in 1989?
Yes.
And what day did he say it was?
Wednesday.
Did he ever tell you that it was Mondays and Thursdays?
No.
Now, did Mr. Bartek, in the 2 times that you interviewed him, ever indicate to you that Mr. Walker had told Mr. Bartek that Mr. Walker claimed to have seen the Menendez brothers playing tennis at the house?
No.
And did you talk to Mr. Bartek about Mr. Walker?
Yes.
And did you ask Mr. Bartek if he had any kind of documentation whatsoever to indicate that Mr. Walker had done work at the Menendez house or was paid for work at the Menendez house?
Yes.
And did he ever produce any checks for you?
No.
Your Honor, I believe the people want to be heard on the next topic.
All right. Is there any further examination of this witness on any other matter?
Not in front of both juries. There's some for the blue jury.
All right. Is there any cross-examination as of this point?
Yes, sir.
Okay, you may conduct that examination.
Early. You're the same investigator who did the tape of the after crime escapades?
Yes.
Your escapade, Your Honor, I object to the form of the question, and this is beyond the scope of this hearing.
All right. The objection is sustained as to the form of the question, but as far as establishing other work she's done, that question would be permissible in a different form.
Thank you, Your Honor. Ms. Erdely, you testified earlier before the jury about your retracing the route taken after these defendants killed their parents, correct?
Yes.
And do you recall being told that Lyle Menendez had said that he and his brother waited around about 5 to 10 minutes after the killings?
Sustained. Objection sustained. It is beyond the scope. We have next question, please.
Certainly, you had the reports from Detective Zoeller regarding his interviews with Grant Walker and Leon Bartek. Is that correct?
Objection, Your Honor. There's no interview from me about Leon Bartek.
Objection overruled.
You were given information and a report taken of an interview with Grant Walker, correct?
Yes.
Did you write any reports in this case?
Objection,
Any of the
Your Honor.
interviews that you have testified to here?
This is improper.
Objection overruled.
You may answer, ma'am.
Yes.
Have you made those reports available to the
I'd like to
prosecution?
approach, Your Honor.
All right, rephrase the question.
No, I'd still like to.
No, just rephrase the question.
Now, you appear to be testifying, is it from memory today, ma'am?
Yes.
You don't have a report in front of you?
Yes.
You do?
Both, yes.
Where is that report?
In my lap.
Now, is that a report of your interview with Grant Walker?
Yes.
Is there another report of an interview with Leon Bartek?
Yes.
Do you have a report from an interview of Mrs. Valdry?
Yes.
Okay. And you've referred to those reports in your testimony today?
Yes.
Your Honor, may I approach?
Well, I'm going to object, Your Honor. It's improper.
All right, you can state your objection at the sidebar here if you like.
One of my favorite supplements is Cunol turmeric. Turmeric helps with healthy joints and inflammation support, and Cunol has the #1 doctor recommended form of turmeric. Cunol, the brand I trust.
All right, we have both juries back, and let's resume with the examination. We'll go back to further direct examination of this witness before the cross-examination continues.
Ms. Zoeller, when you spoke to Grant Walker on November 22nd, 1993, did you ask him about whether or not, prior to his testifying, he had called into a radio talk show to talk about this case?
Yes.
And what did he tell you when you asked him if he had done that?
He said yes, he had.
And would he tell you when it was that he had called into the radio talk show?
No, he couldn't recall.
Now, do you recall his testifying that he really didn't want to get involved in this case?
All right, that's argumentative, and let's not repeat testimony.
If I may approach, Your Honor.
Yes.
Sorry.
Is this next in order then?
This will be Exhibit 403.
We will stipulate that Exhibit 403 is from the Michael Jackson Talk Radio Show from August the 6th of 1993. Is that correct?
That's correct, and it's somewhere between 12 noon and 1 p.m. I hope this is cued right. So. Wait, it's not loud enough.
Fred, you're on 790 KABC Talk Radio with the nationally prominent criminal defense lawyer Barry Tarlow and Michael Jackson. Hi, Fred.
Yes, Michael.
Yes, sir.
Yes, I happen to be a repairman that was at the Menendez's on the Saturday.
Well, they were killed Sunday, weren't they?
Right. And I remember, and I talked to the detective, I remember the parents were there with the two boys doing tennis. And the boys were very disrespectful to their parents. It wasn't the parents at all saying anything negative to the children.
You mean loudmouth, rude, what?
Right. I remember Eric, he was having a fit because he missed a shot. So he,
on the tennis
kind of foul language. And I remember as I was walking by, instantly stopped his vulgarity and turned to me and said, "Hi, how are you doing?" And I thought that was unusual to be able to do that.
What were you repairing?
I was a pool repairman.
Oh, pool. Oh, okay. So you'd seen them before?
This was the first time I'd seen them.
And they were sufficiently rude to their parents that it made a mark on you?
Yes. I remember coming home and telling my wife. I thought that was very unusual.
Yeah. How kind of you to tell us. Thank you very much indeed.
Okay.
All right.
So. Certainly, had you asked Mr. Walker when it was that he called into radio show?
Yes.
Did you tell him you were going to try to locate the tape of his call?
No.
And would he tell you when he called in?
No, he could never recall when it happened.
Is that what he told you?
Yes.
Did you ask him if it was before the trial had begun or after the trial had commenced?
Yes, I did.
And could he tell you if it was before or after?
No.
And did you ask him, was it before you spoke to the detectives or after?
Yes.
And would he answer that?
He couldn't recall.
I have nothing further.
All right, cross-examination.
Do you have a report from that interview now?
Pardon me?
Do you have a report from the November 22nd interview that you had with Grant Walker?
Yes.
Did you write that down somewhere?
Did I write it down somewhere?
Yes, ma'am.
Yes.
Would you care to share that with
Well,
me?
Your Honor, I'm going to object to this on the same grounds as before, and there's no.
Objection overruled.
I don't have that before.
All right, well, the witness, do you have it?
Yes.
Okay.
May I approach, Your Honor?
Yes.
Oh, these are two.
Now, ma'am, you've indicated that you talked to Mr. Walker on the 22nd of November, correct?
Correct.
And when you spoke to him, did he volunteer the information that he had called up the Michael Jackson talk radio show?
No.
Had you known that previously?
Yes.
How did you know that?
I had been informed of that by Lena Starkman at Leslie Abramson's office.
May I have the report, please?
This is a report of the interview of Mr. Walker.
Correct.
Dated November 22nd. While I'm up here, is there any other ones?
Okay, let's go back to the podium and continue your examination. Counsel's remark regarding her objection is stricken from the record. Let's proceed.
Now, Mr. Walker indicated to you that he had called the Michael Jackson talk radio show, correct?
Yes.
And you've heard what he said on that radio show.
Yes.
That's consistent with how he testified, correct?
Objection argument.
Sustained.
Now, he told you on an earlier interview, I believe it was September 9th of 93, is that correct?
Objection, is that a question?
He said, is that correct? So I assume he means it to be a question.
Yes,
Did you
that's
understand it?
No, I did not.
Let's just get this straight. You've talked to Grant Walker 3 times, is that correct?
Correct.
August 19th?
Correct.
And was that just a telephonic?
No.
September 9th
Correct.
and November 22nd.
Correct.
Regarding the November 22nd interview, did he tell you that he used a different name? He didn't use his own name when he called in?
I didn't discuss that with him.
Have you learned that he used a different name when he called the KABC?
Objection, Your Honor, calls for hearsay.
Sustained.
Now, on Thursday, August 19th, 1993, you had an interview with Mr. Walker, correct?
I'm sorry, I can't hear you.
On August 19th, 1993, you had an interview with Mr. Walker.
Correct.
And on that day, he told you that he had been to the Menendez house on August 19th, 1989, exactly 4 years earlier, correct?
Yes.
And he told you that he saw what appeared to be a tennis instructor with Lyle on the court. Is that correct?
Yes.
And that Eric was standing by his parents with a tennis racket in his hand wearing tennis clothes, correct?
Yes.
And that the instructor was on the court near the alley volleying with Lyle, correct?
Yes.
And he told you that after this Saturday, it made such an impression that when he got home, he told his wife that these boys were disrespectful to their parents. Isn't that correct?
Yes.
Did he tell you why he called into KABC Talk Radio?
No.
Now, on September 9th, 1993, you had another interview with him, correct?
Yes.
And he told you that he definitely recalled being there on the Saturday before the killings, correct?
Yes.
He was emphatic that he saw the news of the murders on Monday and remembered being there on Saturday right away. That's what he told you, correct?
Yes.
He told you that he also told his wife about it when he got home on Saturday, correct?
Yes.
Now, you've also testified to a Leon Bartek interview. And,
Objection, Your Honor.
correct?
I withdraw.
Is that right, Ms. Early?
Yes.
And you interviewed Leon Bartek on September 1st?
Correct.
Now, did you also interview him on September 9th?
I'm going to object and ask the years you stated before you left.
Yes.
Yes. September 1st, 1993. Is that correct?
Yes,
And this is after you had gotten the information regarding Grant Walker. Is that right?
yes,
Now, you also, I believe, indicated that you interviewed him again on September 9th. Is that right?
yes,
Was that a telephonic?
yes,
And were there notes from that?
yes,
In addition to September 1st, you have something else. Is that right?
yes.
May I approach, Sean?
Let's just continue here.
Okay. Now, Mr. Bartek indicated to you on September 1st, 1993, that he was there the Wednesday before the murders, correct?
That was one of his statements, yes.
Did you at some point say, you sure you didn't find out about this problem with the heater a couple of Wednesdays before the killings? Did you make that statement to him?
I asked him as much as I possibly could about his recollection.
And did you question him as to whether he was sure that it was the Wednesday before the killings that this heater problem was detected?
I don't know that I used those exact words, but that would be fair to say.
And at some point he said, well, it may have been 2 Wednesdays before?
That was my understanding.
Okay, but he had told you initially he believed it was the Wednesday before the killings, correct?
Correct.
Now, you've also testified as to Virginia Valdry.
Yes,
And I believe your testimony was that on Monday she was upset with you. Was that what you testified to now?
not on Monday, no.
When was it that she became upset with you?
Tuesday. No, I believe that date would be November 30th.
Okay. When was the first time you spoke to Mrs. Valdry?
Monday, November 29th.
Now, when you spoke to Mrs. Valdry, did you tape the conversation?
No,
Did you take notes and then write a report from the notes, or did you just simply get back to your office and write or type up a report?
I took notes.
Your Honor, may I approach?
No, let's just finish it off here.
Okay. Now, you said that on Tuesday she was upset with you, correct?
Correct.
Now, isn't it true that your own report on Tuesday, November 30th, 1993, when you left, you said that she was cooperative?
Your Honor, I think the question is confusing as to whether the report is for Tuesday or for Monday.
All right, why don't you clarify that?
Yes. Do you have the report that I now have dated Tuesday, November 30th, 1993, regarding the statement of Virginia Valdry?
Yes.
And if you would look at the last line of the first page, you make a statement. She just returned from out of town yesterday. She was cooperative. Correct?
Correct.
Now, this report you wrote after you had talked to Mrs. Valdry on Tuesday, November 30th, 1993, correct?
I should look at a calendar to see what dates Monday and Tuesday were. I may have made a typo.
Calendar is right up here on the wall.
Tuesday was November 30th, correct?
Correct.
And you stated that she was cooperative. You never said she was angry when you wrote this report.
That was during our initial interview.
Let's get this clear. You have this report dated Tuesday, November 30th, 1993, correct?
Correct.
You state that she had just returned from out of town and she was cooperative, correct?
Correct.
Now, you've testified that Mrs. Valdry was angry on Tuesday, November 30th, 1993 with you.
The following morning after our interview, yes.
So it wasn't Tuesday that she was angry at you?
I've just stated I probably made a typo on typing the date.
When did you subpoena her?
I did not, another investigator did.
When was it that you first spoke to her?
I know I spoke to her on one day, and then the problem started the next day. It must have been Tuesday then.
That you spoke.
And then Wednesday, the problems started. I'm sorry.
So you were wrong with the dates on that?
Correct.
Okay. When you testified to that fact, what were you relying on?
My memory.
Did you look at your notes?
Do I look at my notes?
Did you, prior to making your...
I had looked at my report, yes.
Did you look at your notes before testifying here today?
No.
You did not?
No.
Did you personally have a conversation with Mrs. Valdry after Tuesday, November 30th of 1993? You personally?
Just the following morning.
And the nature of that conversation was she was to come in to testify?
Correct.
And what seemed to be the problem?
All she stated was she didn't wish to be involved.
And she came in today, correct?
Yes.
And did you provide transportation for her?
No.
She came in voluntarily.
Objection, Your Honor.
Is that correct?
You know why she came in?
Yes.
Why'd she come in?
She was subpoenaed.
And she took the stand and she took an oath to tell the truth and she testified here.
Object on the question, Your Honor.
Your Honor, maybe I should approach on this.
Move on to something else.
I don't have anything at this point, but I would like to take a look at something.
Okay, counsel, you can approach the sidebar here and talk about it.
One of my favorite supplements is Cunol turmeric. Turmeric helps with healthy joints and inflammation support, and Cunol has the #1 doctor recommended form of turmeric. Cunol, the brand I trust.
Ms. Early, I just want to make the record straight. Is it now your testimony that you first interviewed Mrs. Valdry on Tuesday, November 30th?
Yes, for some reason, Mondays and Tuesdays are...
It's all right. You're allowed to make mistakes, but it's nice if you'll admit it. Did you make a mistake when you testified before?
Yes.
All right. So you interviewed her on the Tuesday, and she said she'd come to court. She was cooperative. She said she'd be here on the Wednesday.
Sustain.
Did she say she'd be here on the Wednesday?
Yes.
And do you recall that at about lunchtime on Wednesday, you called and left an urgent message here at the court?
Objection, calls for this.
I'm not asking what the message was.
Overruled. You can answer the question yes or no.
Yes.
And did I return your call?
Yes.
And at that time, did you tell me Mrs. Valdry wasn't coming in voluntarily?
Objection, calls for this.
Sustain.
Did you know by that time on Wednesday that Mrs. Valdry, had you already spoken to her and had she already refused to come in?
Correct.
And subsequent to that, yesterday, Thursday, did Mrs. Valdry show up in the afternoon?
Yes.
And was it then, and did you see her?
Yes.
Did you talk to her?
Yes.
And was it then that you determined that she was angry about having been subpoenaed?
That was her demeanor, yes.
Objection, calls for speculation. There's no punishment.
Overruled. The answer will stand.
Now, You said that you spoke to Mr. Walker about the KABC talk radio call after you received information from Lena Starkman from my office. Is that
Correct.
And did you receive the information from Mrs. Starkman after Mr. Walker had testified?
Yes.
And was it your understanding that someone had contacted my office concerning KABC talk radio
Yes.
after Mr. Walker testified?
Yes.
I have nothing further.
Anything else?
Just very briefly. Now, when you went to talk to Grant Walker after he testified in this court?
Objection, Your Honor. Assumes facts not in evidence.
Overruled.
When you went to talk to Grant Walker after he had testified in this court, ma'am, did he voluntarily give you names of certain customers that he had?
Objection, Your Honor. Beyond the scope.
Overruled. You can answer that yes or no.
Yes.
Thank you. Nothing further.
All right. Anything else?
The names he gave you were the same three people we're talking about, right? Valdry, Chin, and Ingraham.
Correct.
Nothing further.
All right. You may step down. You're not excused. You may call your next witness before both juries. All right.
Detective Zoeller, on August 22nd, 1989, did you interview Marzi Eisenberg?
Yes.
And in the course of that interview, in describing Jose Menendez, did she tell you he was a tough businessman, he liked a good fight in the boardroom?
Yes.
Did she tell you he was very stern and had a way about him of revealing people's shortcomings?
Yes, he did. Yes, she did. I'm sorry.
Did she tell you that he, meaning Jose Menendez, like in his business dealings, ran a tight ship? He ran the family.
Yes.
Did she also tell you that she spoke to Kitty Menendez by phone often but was not close to her?
Yes.
No. Okay. Did you also interview Karen Farrell on 2 different dates in 1993?
Yes, I did.
All right. Was the first interview, I'm sorry. Was the first interview on June 2nd, 1993? The first of the 1993 interviews?
I don't recall specifically, but if you have a date there, I'll rely on that.
Okay. Let me show you.
Yes, that's correct.
Okay, let me just show you this.
Yes.
And during the course of the interview with Karen Farrell on June 2nd, 1993, did she tell you that she had lunch with Kitty Menendez the Wednesday before she died?
Yes, she did.
And did you have another interview with Karen Farrell on October 25th, 1993?
Yes.
And did she tell you again in that interview that she last saw Kitty on Wednesday, August 16th, 1989?
Yes, she did.
And in the interview of October 25th, 1993, did Mrs. Farrell tell you that on Saturday, August 19th, 1989, she phoned Kitty and told Kitty that she, Mrs. Farrell, and her husband were planning to spend Sunday in Santa Barbara?
Yes.
Now, you also interviewed Grant Walker, is that correct?
That's correct.
And you recall when Mr. Walker testified, he claimed that he got the names of the brothers wrong and he switched which brother was doing various things.
Objection irrelevant will be responsive to that.
Overruled. You asked about his testimony or when he was speaking with Secretary Zoeller?
During his, you were present for his testimony, were you not?
That's correct.
All right. Just sit down for a second. All right, first of all, when you interviewed Grant Walker, was that on July 25th, 1993?
Yes.
Was that the first time you interviewed him?
Yes, it was.
And did you first learn of his existence on July 21st, 1993?
For approximately the 21st, that's correct.
Okay. And on the 25th of July, 1993, did he tell you that he had been watching the news in reference to the Lyle and Eric Menendez murder trial, where the defense is claiming self-defense?
He indicated to me, I'm not sure watching the news is a proper characterization of what he said.
But that,
His reference was to the news.
but you wrote the word watching
That's
in your
correct.
report. And do you think you wrote it, I mean, did you just make the word up, or was that based on what he was telling you?
It was my impression. I don't recall the word watching. It was my impression. It had come from the news media.
Okay. Well, did you ask him specifically, was he watching the trial?
I did not ask him.
Did you know that his wife watched court TV every day?
Objection calls for hearsay.
Sustained.
Did he tell you that his wife was watching the transmissions and taping it?
Objection calls for hearsay.
Overruled. No.
Were you present in the courthouse corridor after Mr. Walker testified?
At which point? Immediately after he testified?
Well, during the course of the day, did you observe him and his wife out in the hallway?
Yes.
Did you see his wife go over to Terry Moran, the commentator from
Excuse me, Your
Court
Honor,
TV?
I object to this as being irrelevant as to what his wife did.
Sustained.
Did you see his wife combing his hair before he came back in to resume his testimony?
Same objection, Your Honor.
Overruled. No, I didn't notice.
Did you ask Mr. Walker what specific news sources he had been exposed to before he contacted the police?
He didn't contact the police, as to my understanding.
Mrs. Walker contacted the police.
And I
Objection
did
calls
not.
for hearsay.
Objection sustained to the question. The answer is stricken.
The question is, before he spoke to you, well, first of all, you went to his home, correct?
That's correct.
He let you in.
Yes, he did.
Was he cooperative?
He was.
Fine. And here is someone who's telling you that he's been following the news somehow about a case that's in progress, correct?
Yes,
And he claims to have information for you, correct?
that's correct.
Now, did you have any concern about what the source of his information might be?
Other than saying that it was the news, no.
Well, did you ask him specifically what he had heard about the case from the news?
Objection irrelevant.
Overruled. You can answer that question. No.
Did you ask him if he had seen Any television coverage that showed Eric and Lyle Menendez?
I did not know.
Excuse me, Your Honor. Now, did he tell you when you interviewed him on July 25th that he had repeated his observations to Mr. Leon Bartek?
No.
And in fact, Detective Zoeller, after speaking to Mr. Walker, did you contact Leon Bartek?
Yes.
And when was it that you contacted Mr. Bartek?
Quite a while after I had spoken to Mr. Walker. It was after your investigator had contacted Mr. Bartek.
And did you ever prepare a report of your contact with Mr. Bartek?
No, I did not.
Do you recall Mr. Bartek testifying that Mr. Walker told Mr. Bartek that what Mr. Walker had observed was one of the sons in an argument with his father?
Objection irrelevant, what he recalls.
Sustained.
It's only foundationally
Well,
wrong.
let's get to the ultimate question.
Did Mr. Bartek, before he testified, tell you that Mr. Walker had told him that he, Mr. Walker, had observed an argument between one of the sons and their father?
No.
Did you ever ask Mr. Bartek before he testified whether or not Mr. Walker had ever told him the story of having seen the Menendez brothers?
No, I did not.
And did Mr. Walker, before he testified, ever tell you that he had told his story to Mr. Bartek?
No.
Did he tell you, though, that he had told it to his wife?
Yes, he did.
And did he tell you that he told it to his wife because boys being vulgar to their parents was so shocking to him?
Not in that characterization, no.
Do you know if the Walkers have children?
Your Honor, that's irrelevant.
Sustained.
Did you inquire whether they had ever had contact with teenagers in their life?
Objection
Sustained.
argumentative.
Sustained, it's irrelevant.
Now, when you spoke to Mr. Walker in July of 1993, did he tell you that one of the boys in particular was saying the rude things to the parent, or did he tell you it was both of them equally?
He made an indication that it was both of them.
Now, he testified, strike that. Before he testified, did you or did anyone in your presence go over the police report with him?
Objection irrelevant.
Overruled.
Not to my knowledge.
No one sat down with him before he testified and asked him if what you had written down was accurate?
Not to my knowledge.
Then you must have been surprised when he changed
Okay,
his
counsel,
story.
let's not ask these questions. Let's finish it off.
Did he tell you that it was Eric who was being rude on the tennis court to his mother?
May I look at a report, please?
Oh, certainly.
I think I have it in front of me if I
Yours?
may refer to it, yes.
Could I have my reports back, please? Cindy's report. Please. We're gonna put.
All right, your next question, please.
He did indicate who it was and independently. Did not.
Okay. He didn't say it was Eric and he didn't say it was Lyle.
That's correct.
And he didn't say it was the older one and he didn't say it was the younger one.
That's correct.
He simply said both of them.
That's correct.
I have nothing further.
All right, any examination by Lyle Menendez counsel before both juries?
No, Your Honor.
Any cross-examination?
No.
All right, let me see counsel at the sidebar regarding our schedule here. All right, counsel, you have some stipulations.
Yes, Your Honor.
Counsel may be stipulated that Exhibit 372, 2 pages of records with the notation HRC are true and correct copies of the records of the Hair Replacement Corporation with regard to the hairpiece for Lyle Menendez.
Stipulated?
May be further stipulated that Exhibit 384 is a collection of documents which track the movement of the Menendez family between the 17th of March, 1989, and the end of that month.
So stipulated as to the family members testified to.
Yes. And may be further stipulated that Exhibit 392, a 2-page undergraduate announcement from Princeton University indicating that spring recess was March 11th to March 19th, is a true and accurate reflection of the spring break dates for that year.
So stipulated.
May it further be stipulated that Kitty Menendez's car was stolen March 25th, 1989.
So stipulated.
Thank you.
All right, and it's my understanding there's going to be some brief testimony for the gold jury, and then we'll have some more brief testimony with the blue jury. And after the testimony with the gold jury, I'll be excusing you for the day. So I'd ask that the blue jurors go back into your jury room since you're closer here and just wait there a short period of time, and then we'll have you come out. And then we'll be finished with our testimony in the case. All right, the blue jury has left and the gold jury is still remaining. You may continue your examination of the
Thank
witness.
you, Your Honor. Detective Zoeller, on November 2nd, 1993, did you interview Jamie Pisarcik?
Yes.
And do you have your report with you of that interview?
I do.
I'm sorry, for this question, I do need
Just for one question?
one question.
Well, let's get to the rest of it then and come back to it, whatever else you have.
As part of that interview, did you discuss with her, or did she discuss with you, efforts to receive information about whether Mr. Menendez had paid for a sponsorship for her?
Yes.
And did she produce a document which indicated that she had received such information?
Yes, she did.
And was that document dated February 1990?
That's correct.
And did she indicate to you when it was that she sought information with regard to that issue?
I believe so, yes.
And can you tell me when it was she said that she sought that information? What prompted her to seek that information?
Information that she received in reference to the trial.
Can you be more specific? What did she tell you? You can refer to your report if that's helpful.
I don't recall any more specifics than that.
Detective Zoeller, does your report indicate Jamie said that after she heard during the trial that Mr. Menendez had paid for her sponsorship by using an anonymous name, she contacted Mr. Nall to ask him of the sponsorship for her play in Europe? Is that what your report reads?
It does.
And does that accurately reflect what Jamie Pisarcik told you on that day?
Pretty much so, yes, in substance.
So she indicated that she heard the information during the trial. Is that correct?
That's what my understanding was, yes.
And at that same interview, did she indicate to you where she was living at the time of Lau Menendez's arrest?
Yes,
And where did she say she was living?
at the Marina City Club apartments.
And did she say she was living with him at the time?
I believe so, yes.
And that was contrary to her testimony here, is that correct?
Sustained.
Did she also discuss with you at that time buying books for Lau Menendez?
Yes,
And did she talk about going to the Walden bookstore all the time and buying him books?
that's correct.
She did not indicate that she went to a number of different bookstores, is that correct?
I think is what she said is that she bought books for him all the time and specifically went to the Walden bookstore.
Would it refresh your recollection to look at your report?
No, I recall it.
Does your report say she said that she was going to the Walden bookstore all the time buying him books?
That's correct.
And she indicated just general subjects?
Correct.
And you were asking her specifically what types of books she bought, is that correct?
That's correct.
And the only specific she could give you was a book on sign language, is that correct?
That's correct.
And she did not remember or mention to you November 2nd, 1993, anything about buying a book on the BBC.
That's correct.
Is that correct? Detective Zoeller, during the course of this trial, did you observe Dr. Fairstein, a psychiatrist for the
I
process?
would ask that this is irrelevant.
Sustained.
Detective Zoeller, you were here in the courtroom when a man who'd worked as a bodyguard briefly for Lau Menendez named Wenskowski testified, is that correct?
That's correct.
And you were here when an associate of Lau Menendez's, Glenn Stevens, testified, is that correct?
That's correct.
Mr. Wenskowski was asked if when he came out here to testify, if you
Your
took,
Honor, I object to this as being improper for rebuttal.
Sustained.
may I approach, Your Honor?
Yes.
Thank you.
Skating for over 45 years has taken a toll on my body. I take Cunol turmeric because it helps with healthy joints and inflammation support. Why Cunol? It has superior absorption compared to regular turmeric. Cunol, the brand I trust.
You remember who Mr. Stevens was also, I believe?
That's correct.
And Mr. Wenskowski, when he was being questioned by Mr. Burt, was asked whether when he was out here to testify for the prosecution, you took him to a topless bar. Do you remember that question?
I remember it.
And Mr. Wenskowski said adamantly it never happened. He would have
Sustained.
indicated that it
Well,
had.
let's not go rehash his testimony. Why don't you ask him, the witness, what
Well, the
he
question
recalls
is,
happening?
two witnesses have testified differently, and I wanted him to tell
Well,
me.
again, you have to ask him directly what you want to ask him.
Did you take Mr. Wenskowski and Mr. Stevens to a topless bar when they came out here to testify for the prosecution?
Yes, I did.
Thank you. I have one other question for both juries then, Your Honor.
Your Honor, maybe it could be asked in front of this jury, and then I can get them for the other sister.
All right, let's do it that way. It's just one question, assuming it will be.
When you interviewed Jamie Pisarcik about the conversation she claimed to have overheard, or conversation she claimed to have had with Eric Menendez about Lau Menendez's hairpiece, Did she give you some details?
Yes,
And did you write those in your report?
yes.
And can you tell us now how she described that conversation to you November 2nd, 1993?
Now, which conversation are you referring to?
This is the conversation with regard to Eric supposedly knowing that Lyle had a hairpiece.
I'll preface it by saying when I asked her if anybody had known about the hairpiece, particularly Eric, and she said yes, that he had found out in the spring of 1989. I tried to pin her down on a date, which she...
That's not my question.
Okay.
I'm asking about, let me do it this way.
Okay.
Is it true that in your report you recorded her statement to you as follows? She, meaning Jamie Pizarczyk, was there at the house in Beverly Hills when Eric had overheard their mother talking about the hairpiece. She remembers that Eric laughed and said, "I can't believe it. That's why his hair is never out of place." Is that what you wrote in your report?
That's what the report says, yes.
Thank you.
All right. Any examination of this witness by the prosecution?
Yes. Detective Zoeller interviewing Ms. Pizarczyk and asking her about the cases that she had acquired for Lyle Menendez. Did she use the term children getting off after killing their parents?
Yes.
Thank you. Nothing further.
Anything else? Sure. Certainly.
It is stipulated that Exhibit 327, which is a letter signed Dr. Dennis Munjak, in fact bears the handwriting of Dr. Oziel, and a handwriting expert would so testify. It is further stipulated that the case was presented to the Los Angeles County District Attorney's Office for prosecution against Dr. Oziel, and that the Los Angeles County District Attorney's Office declined to prosecute due to the statute of limitations. Okay.
All right. Anything else before the gold jury? The defense rests in its rebuttal.
Your Honor? Okay, never mind. I thought there was one more thing.
All right. As to the gold jury, then, I'm going to be letting you go at this point, and that's the end of the evidence phase of the trial. And the next phase of the case for you will be the argument. The lawyers will argue the case to the jury, and then I will instruct the jury. There is still some matters that the lawyers and I have to resolve regarding the instructions I will give you on the law. And there is also some further discussion the lawyers and I have regarding some of the exhibits. There's about over 400 exhibits, and periodically we've been reviewing them and making certain determinations as to which exhibits you will actually have with you in the jury room during your deliberations. And that discussion is still going on. That's going to happen on Monday. What I'm going to do is order you to return to court on Tuesday at 9 o'clock. It's possible, slightly possible, that it might be delayed until Wednesday. So what I'm going to do is ask that you just make a note now, come in Tuesday at 9 o'clock for argument. And if there is going to be a delay until Wednesday, we'll talk to you Monday afternoon and let you know about it. Otherwise, you are all to return Tuesday at 9 o'clock for argument in this case. I'll understand Tuesday, 9 o'clock, go to the jury room, at which time argument will just start. And if we're going to change that, we'll call you and let you know Wednesday instead, okay?
Which jury?
You just go back to your old jury room until we get organized, and then we'll have you come in. All right, we'll see you back here Monday. Don't discuss this case with anyone. Don't form any final opinions about it. Don't look at any of the news coverage. We'll see you all back here Tuesday. All right, okay. Is back in court. Further examination of the witness.
Detective Zoeller, do you recall during the interview that you conducted with Eric Menendez in September of 1989, you asked him if he had traveled under the name of Eric Tam?
Yes.
And were you aware at that time that a reservation had been made on August 31st, 1989?
Is hearsay, I believe.
I'm just asking what his information.
Sustained if you're asking it.
Why did you ask him that question? Why did you ask Eric if he had traveled, in fact, under the name of Eric Tan, back to Los Angeles following the memorial service in New Jersey? Did you have such information?
Yes.
And I'd like to mark this document, Your Honor.
All right, do you have other questions of the witness on other subjects, or is this it? Is this going to be the end of your examination, or do you have other subjects?
I just have one other subject.
We'll go on to the other subject then.
November 2nd, 1993, you interviewed Jamie Pisarcik. Is that correct?
Yes.
And did you, at some point in the interview, focus her attention on Lyle's hairpiece?
Yes, I did.
And did you ask her at some point in the interview if anyone else knew that Lyle had a hairpiece, particularly Eric?
Yes, I did.
And did she tell you that Eric didn't know from the beginning, but he found out in the spring of 1989?
That's correct.
Now, was she sure at that point that it was the spring of 1989, or did she think it might have been the summer of 1989?
I tried to pin her down on the date, and she could not give me a date, and the best she could come up with was the spring of 1989.
Now, when she testified here, she said late spring or summer. Is that what she had said to you, spring or summer?
Objection argumentative.
Sustained as to the form of the question.
Had she said to you spring or summer?
No,
She just said spring?
that's correct.
Now, did she tell you that, well, strike that. With respect to the way this interview went, did she make that statement to you? And did you then ask her, how do you know that's when he found out?
I did not ask her that question, no.
All right. So did she just volunteer that she knew because she was there at the house in Beverly Hills when Eric overheard their mother talking about the hairpiece?
That was my understanding, yes.
Well, that's what she told you. Correct?
Not exactly. When she made that statement on the stand, I reviewed my notes to see if she had stated that, and my notes don't indicate it. And then I tried to remember why I made that statement in the report, and it was my understanding that Eric found out through his mother.
Well, that's what she told you. Were you making it up?
No, that was my understanding.
Of what she told you?
Correct.
She was telling you that Eric heard his mother
Correct.
say something.
Correct.
And she told you that she knew that.
Correct.
And she claimed to have been there at the time this is going on. Because she claims that Eric found out in the spring of 89, and she claims she was there at the time. Correct?
That's what I'm not sure about, whether she was there when the mother told him or whether she was or was not there.
Well, why don't I read you what you wrote in your report? She said that Eric didn't know from the beginning, but he found out in the spring of 1989. She was there at the house in Beverly Hills when Eric had overheard their mother talking about the hairpiece. That's what you put in your report, correct?
That's correct.
And you are aware that before testifying, Ms. Pisarcik was given this report and asked to review it, and she did not correct that portion.
I wasn't aware of that until she testified to that on the stand.
All right, but she did testify to that on the stand.
That's correct.
And you didn't correct it before she testified.
Objection argumentative.
Overruled.
Correct?
No, I did not.
And you haven't corrected it since.
No, I have not.
Are you trying to correct it now during the last 5
Objection
minutes of this
argumentative.
trial?
Sustained.
Did you ask Ms. Pisarcik where she was at the time she supposedly had the conversation with Eric Menendez about the hairpiece?
No,
Did you ask her what she had been doing beforehand?
I did not.
In fact, you didn't ask her any questions about it at all, did you? Except, you didn't ask her any follow-up questions.
No,
And was this particular interview with her tape recorded?
it was not.
Now, with respect to your notes do indicate, do they not, that the time at which she supposedly had this conversation with Eric Menendez was the spring of 1989.
That's correct.
I might have a moment. How long after the interview of November 2nd was your report of that interview prepared?
Within a day, I believe.
And within a day, do you dictate off your notes?
I take the information from my notes.
And do you often put in other information into the report that doesn't appear in the notes, but that you remember?
Yes.
I have nothing further on this topic. I think they.
All right, why don't you approach on that?
Just one question, Your Honor.
Yes.
Detective Zoeller, November 2nd, 1993, Jamie Pisarcik indicated to you that it was her best approximation that she heard Eric Menendez talk about the wig of his older brother in the spring of 1989. Is that correct?
That's correct.
So over 4 years later, she's
That's
estimating?
correct.
Thank you.
Overall, the answer will stand.
Show me, if I may first do this, Detective Zoeller, where in your report it says it's her best approximation, or she's guessing, or she's estimating. Would you show me?
It's not in the report.
All right, anything else? Any further evidence to be offered by the defendant, Eric Menendez?
Yes, ma'am. Would you recall Ms. Beverly for testimony?
All right, please get her. We're almost through, ladies and gentlemen. This will be it. This is the last witness and the last evidence, and then it'll be excused until the argument is completed on the other defendants. So we're getting there. Very short, more testimony.
We're waiting for the jury. I mean, for the witness.
She's here now. Let's go ahead. Why don't you get back on the witness stand, please? All right, state your name again for us.
Cynthia Erdely.
All right.
Ms. Erdely, do you know who Antoinette Browers is?
I do.
What's her name? You, Loden. Loden?
All right.
Did Antoinette Browers identify herself to you as a lieutenant of Bel Air Patrol who was on duty at the Menendez home over several shifts?
Yes.
And you're aware of the fact that she was called as a witness in this case by the prosecution?
Yes.
She's recently married and she has another last name now, Loden, I think.
That I'm not aware of, her new last name.
Okay.
No.
Now, in do you have a copy of your report concerning your interview with Antoinette Browers with you?
Yes.
Would you please take it out? Now, can you tell me first of all, did you interview Antoinette Browers?
Yes.
And what day did you interview her on?
On March 30th, 1993.
And at the time that you interviewed her on March 30th, 1993, did she tell you whether or not she had yet been contacted by the police?
She said she had not.
And when you interviewed her on March 30th, 1993, where did the interview take place?
At the offices of Bel Air Security Patrol at Bel Air Road and Sunset Boulevard.
And did you have with you a set of Bel Air Patrol documents?
I did.
And Your Honor, I have 3 sheets, what appear to be a schedule that I'd like to mark 405.
405.
And if I can approach. Ms. Erdley, showing you these 3 sheets, can you tell us what Exhibit 405 is?
That's the work schedule for 722 North Elm Drive from Bel Air Security Guard.
And did you have a copy of that work schedule with you when you interviewed Antoinette Browers in March of 1993?
I did.
And were you pointing out to Lieutenant Browers the dates upon which the schedule indicate she worked at 722 Elm?
Yes.
And so was the schedule being referred to by both of you during the interview?
Yes.
And Ms. Erdley, with respect to your interview with Ms. Browers, were you trying to discern a specific fact with regard to interviewing her?
Yes.
And what was it you were trying to determine?
Her recollections of who was at the house on specifically August 31st, September 1st, September 7th, and September 8th, if she could.
Okay. And therefore, did you first of all, did the schedule indicate that that she worked on September 1st?
Yes.
And did the schedule indicate that she worked basically a graveyard shift where she'd come on duty just before midnight September 1st and then be on duty overnight to September 2nd?
Correct.
And did she tell you that she recalled that night and going to the house that night, September 1st? And did she tell you that she received some information from the guard that she was relieving concerning the house that night?
Objection calls for hearsay.
Overruled.
Yes.
And what did she tell you in that regard?
That she was informed there was no one in the house.
When she got there on September 1st?
Yes.
And did she tell you that at the beginning of a shift, she would always do a tour with the guard who was going off and be advised as to whether there were people in the house and where they were?
Yes.
And did she indicate that that occurred when she worked that night, September 1st?
Yes.
Now, did you also discuss with her the information on the schedule concerning September 7th?
Yes.
And what shift does the schedule for September 7th indicate?
Shows she worked a day shift that started at 8 a.m.
And now, with respect to that date, did she indicate whether or not she saw any family member and any friends of family members at the house?
Yes.
Just to back up for a minute, did she claim to you, when you interviewed her in March, to have seen Eric Menendez on the morning of September 2nd?
No.
Did she claim to you that she saw any friend of Eric Menendez's on the morning of September 2nd?
No.
Now, with respect to September 7th, did she tell you that she did see a friend of Eric's at the house after she got there on September 7th?
Yes.
And did she describe to you what that friend was wearing on September 7th?
Yes.
And what was it?
Jeans and a t-shirt.
Did she ever describe to you seeing Eric Menendez or any friend of Eric's in sleepwear or pajamas or a robe or anything like that?
No.
Now, when you interviewed Ms. Browers on March 30th, 1993, did you interview other Bel Air patrol officers at the same time?
Objection irrelevant.
Overruled. You can say that yes or no to that.
Yes.
And were you discussing the schedules with them as well?
Yes.
And was she present when you were discussing the schedule with other officers?
No.
So did you interview each one individually?
Yes.
I have nothing further.
Cross-examination.
Thank you, Your Honor. Ms. Browers, you have
This is Ms. Erdley.
Sorry.
I know it's
getting late. Ms. Erdley, about Ms. Browers, you have a report, a 3-page report?
Yes.
Is that right? Now, you don't have it dated, do you?
It's dated on a cover sheet.
That's why I didn't have to go look at the cover sheet.
Okay, Mayor Pro Tem.
Yes.
That's why I asked her, because I never cover sheet.
Did you tape record this interview?
No.
And I suppose you have notes from this interview too?
Yes.
Did you check your notes before you testified today?
No, I referred to my report. Typed report, I'm sorry.
So when you went to talk to Antoinette Bowers on the 30th of March, you had notes from the interview, and then you made a report from it, correct?
I think the question's confusing, Your Honor.
All right, let's move on.
Okay. Did you ask her specific questions about whether or not anyone had been in the room that she was not aware of? In Eric Menendez's bedroom?
Your Honor, I don't understand the question.
Rephrase the question.
Okay. You were asked specifically about two dates, September 1st and September 7th, I believe, and 8th, or 3 dates. Is that correct?
4 dates altogether.
Specifically, though, September 1st.
Correct, that was one of them.
And did you ask whether she had ever knocked on Eric Menendez's bedroom?
No,
To summons him for anything? You never asked her about that?
it wasn't a necessary question. She already described the condition of the house to me, that there was no one there, and she made her tour.
I have nothing further.
Anything else? No. All right, you may step down. Any further evidence to be offered by the defendant, Eric Menendez? All right.
I'll do the first stipulation. It is stipulated that Exhibit 327, a letter bearing the signature of Dr. Dennis Munjak, has been examined by a question document examiner and been found to contain the handwriting of Dr. Jerome Oziel. It is further stipulated that the case against Dr. Oziel was taken to the Los Angeles County District Attorney's Office by the State Bureau of Consumer Affairs, and that the District Attorney's Office declined to prosecute the case against Dr. Oziel due to the statute of limitations.
So stipulated.
And I'd just like to mark the American Express gold card of Mark Heffernan as 400.
No.
Good 400?
No, way headed there. I think we're at 406.
No, I
You had previously marked it as 400. This is the American Express record.
Yes.
Is that it?
Yes, we're going to reserve it for the blue board. And I have two stipulations with respect to this jury. The counsel, will you stipulate that Craig Signorelli's phone number in August and September of 1989 was area code 818-888-1273 out of Canoga Park, and that Carlos Menendez's phone number was area code 201-431-1257 out of Freehold, New Jersey.
Yes, so stipulated.
Anything else? All right, there is no further evidence to be offered on surrebuttal or on, in the case of People versus Eric Menendez. That's the end of all of the evidence. The argument will be for the gold jury first. The reason I wanted to keep you here was because we won't need you back here until the argument for the gold jury is completed. And first of all, let me say that it's very important that, as I've said to you before, that you make your decision based only on the evidence you hear in this courtroom and my instructions on the law. And it's very important that you not be concerned about what goes on when you're out of the courtroom and any evidence or argument or proceedings that relate to the other defendant. Your goal and role is to decide the case of People versus Eric Menendez alone and make that decision based on the evidence you have heard and my instructions on the law. So during the time there's argument going on involving the other defendant, it's even more important at that stage that you not concern yourself and not be made aware of what's going on, and wait until you get back here for the argument involving the case of Eric Menendez, which will take place. Yes. All right, sure. This just to finish off my remarks, as far as your return date, I'm going to ask that you return on Friday of next week, with the understanding that it's possible that we won't need you until the following Monday. So what we'll do is let you know as the week progresses whether we're going to need you Friday, which is the 10th, or Monday, the 13th. At this point, just to keep everybody aware of the next date, I want you to make note to be here Friday at 9 o'clock. But if it looks like we're not going to get to the argument for you folks until Monday, we'll call you and have you come in Monday at 9 o'clock. And by a little later next week, or even the early part of next week, we should be in a better position to know exactly when we'll want you, either Friday or Monday. But at this point, make a note, we'll want you back on Friday unless you hear otherwise. So that's it for the testimony. I'm sorry to keep you here so late, but it was necessary to get this thing done so that we can get to the next phase of the trial. And again, don't discuss this case with anyone. Don't form any final opinions about it. There is still the argument and my instructions before you can deliberate and go into the jury room and discuss it among yourselves. And don't permit yourselves to be exposed to anything about this case in any form whatsoever outside the courtroom. Have a good weekend, a good week, and we'll see you next Friday unless we hear otherwise. You hear otherwise. Memoranda that you want to file it Monday morning at 9 o'clock so that I'll have it available. And I want both defense teams here Monday as well to discuss jury instructions and exhibits and anything else that has to be resolved.
And then, Your Honor, if we complete that work on Monday or whenever, for the days when the case is being argued, can Eric Menendez remain at the county jail?
Yeah.
Your Honor, I have one other case to give to the
Yeah,
court.
anybody who has anything you want me to consider relating to jury instructions other than the memorandum that the Eric Menendez team is filing on Monday, I'd like to see it now.
And Your Honor, I have here a packet of the tapes that people are objecting to regarding Judalon Smith. And I don't know if the court wants to review them over the weekend or not.
Are they in the form that they're going to be submitted to the jury?
Well, yes, some of them contain two tapes. One of them will say excerpt, and the excerpt is the one the defense wants.
Okay, yeah, you give them to me.
Okay, and one of them, I think, has already been excluded by the court, but is being reoffered by the defense. All right, so I'll submit these with the rubber band.
Are these objections being made because of the way in which they've been redacted or because the people objected originally? I think it would help.
We've objected originally.